I'd like to open our protest hearing. I want to welcome those of you who came to view, and welcome our board members. Thank you for coming. I want to remind you that you do have information in a packet that was provided for you. Feel free to peruse it and ask questions if you need to at any point in time. So I would like to refer to our attorney for him to get us started for today. Thank you, sir.
Good morning, Madam Chair, members of the board. As you know, because we were recently together considering on preliminary consideration of the election protests filed by the Honorable Jefferson Griffin in the Associate Supreme Court Justice Seat 6 race in the state of North Carolina. We're now here for the evidentiary portion of the protest hearings. So the purpose of the meeting today is for you to hear testimony and gather evidence concerning the 3 protests that are now within your jurisdiction following the state board's order, which eliminated one of the 4 protests that were filed here in Rockingham County. So today, I have a recommendation of procedure to get us moving. I know that we have somewhat of a limited schedule, so we'll try to be expeditious in the use of the board's time and the protesters and all interested parties' time today. So again, there are 3 protests before you. The state board has asked us to consolidate all of the protests into a single order following the conclusion of the proceedings today. So my suggestion is going to be to use that same format in the presentation of evidence to you. So what I would suggest is that the protester have an opportunity and the other party have an opportunity to present an argument to you, an opening statement, if you will, concerning all 3 of the protests. And then once we have some preliminary statements, move into the evidentiary portion of the hearing. My recommendation would be that you go in order of the protests that we termed 1, 2, and 3 during the preliminary consideration meeting. That is the protest concerning ineligible voters due to death. Number 1, ineligible voters due to felony conviction. Number 2, and then the ineligible voter because of registration issues, protest 3. So we can present evidence on each one of those in turn and have sort of finish one set of protests before moving to the other, so you can keep the information fresh in your mind about each one. And then you'll deliberate at the end of the evidentiary portion of the hearings on all 3 together, rather than doing deliberation on 1, coming back, deliberation on 2, coming back, deliberation on 3. So you won't deliberate until the end, but you'll hear evidence and testimony in a cohesive way on each protest one at a time. Does that make sense to you, Madam Chair, as a way to proceed?
Yes, sir.
All right. So the first thing I would recommend is that we swear in any and all witnesses who may give testimony today, and we can do that all at once. If you are prepared and plan to give testimony today, if you'll stand and the clerk will swear you in. Lawyers do not have to be sworn if they're presenting argument. Do we have a...
I'm counsel for the Griffin campaign. My expectation was that, or my hope, my argument was that the affidavits we submitted with our protest would be received into evidence, so we don't have the affiant who submitted those, Mr. Bonifay, here today. Obviously, he's pulled in a lot of different directions, but the statute does allow testimony by affidavits, so my hope was that we would do it that way, and then perhaps hear from the director or staff as well.
Understood, and the statutes do allow for affidavits to serve as evidence that you can consider in the hearings. And so what I'd suggest is when you're prepared to present your case, you can reference those and have them entered into the record, and we can do it that way. Okay, so swearing in witnesses. Anybody planning to provide testimony or evidence today in the audience? Okay. Doesn't look like we have any witnesses that need to be sworn. And as you come up today, if you'll just identify yourselves for the record and by name and role in the case. All right, so with that, it seems as if you're ready to move forward with your evidentiary hearing. Let me just give you a brief understanding of what your job is today. So as you hear the evidence and testimony, or as you hear the evidence come before you, there won't be any testimony apparently, you can have it in the back of your mind. So in a protest hearing, the burden of proof is on the protester. And the protester, in order to sustain election protest, the county board must find substantial evidence of an irregularity or misconduct that impacted the election results. Substantial evidence is relevant evidence as a reasonable mind might accept as adequate to support the conclusion that certain irregularities occurred and that they swayed the outcome of the election. So that's the standard before you today. In a multi-county election such as this one, when the protester has alleged that enough voters statewide are ineligible to vote, which has impacted the election, the protester's burden before you today is to establish there's a substantial evidence to believe that a violation of election law or other irregularity or misconduct did occur. And if the protester meets that burden, then the county board shall order that the protest and the county board's decision be sent to the state board, right? Because the idea being that there may not be enough votes that were subject to irregularity that would impact the statewide race here in Rockingham County, but when aggregated statewide, there could be. All right, does that make sense to everyone? Okay, with that, Madam Chair, if you're so inclined, since the protester has the burden, I think it makes sense for the protester to present their protest to you.
Thank you, Madam Chair, board members. I will try to keep it brief. My name is Jonathan Marks. I'm here on behalf of the Jefferson Griffin campaign. We're here because we believe that there's three types of irregularities that have occurred, not just here, but statewide, that have affected the Supreme Court race. One is persons voting who were ineligible by reason of a felony. One is persons voting who were ineligible because they died in between casting a ballot and election day. And the third is that people have cast ballots who were ineligible because they weren't validly registered. And usually that's because they hadn't completed the registration process, they were removed from the registration rolls, or their return mailing was returned undeliverable. We have submitted as evidence affidavits of Mr. Ryan Bonifay, who's a data analyst. Mr. Bonifay's affidavits show, or they're based on an analysis of State Board of Elections records. So when we ask, how do we know that deceased individuals cast a ballot in Rockingham County, the way we know is because by looking at State Board of Elections records, we can see who died, we can see the death records that they've received and they've sent out to the counties, and we can look at people's voter history and see that they have cast a ballot that was accepted into the system. Now, we also know that sometimes counties make efforts to retrieve those ballots, and we don't have access to that information. So we look forward to hearing more about that, hopefully from the elections director. Similarly, with respect to felons, right? The State Board of Elections receives felony conviction information from the prisons or from courts, sends them out to the counties. We compare that information to voter history files to see who's cast a ballot that was convicted of a felony in between casting a ballot on election day, right? Because you have to be eligible to vote on election day, cast a valid vote. Similarly, with respect to registration. So my request would be that the board receive those affidavits into evidence and consider them to have essentially established a prima facie case that ineligible folks have cast a ballot here. And if there's any essentially counter evidence to show that those ballots have been retrieved or removed during the canvass process, I'd request an opportunity to examine a witness on that. Any questions for me? Appreciate your time.
Is anyone here from Justice Riggs?
Yes. And my name is Matthew Harbin. I'm here on behalf of Justice Riggs' campaign in response to Judge Griffin's protest. And
Would you speak louder, please?
sure, my name is Matthew Harbin. I'm here on behalf of Justice Riggs' campaign in response to Judge Griffin's protest in this matter. We would want to point out essentially 4 things about the protests. So one is we're here today on their protests, which they have an affirmative obligation to send notice of to the affected voters. The notice in this matter was a postcard with a QR code. They did not send the documents that indicated what the basis of the protest was, the information for the voter to be able to look at and review. They did not even indicate in the postcard that their vote was specifically being protested. It says it may be, and there's a QR code that does not give the information. I think instead it takes them to a website, the State Board of Election website, rather than providing the actual documents that were sent to the State Board. So there's a failure there. It's an important part of the process. The second point is this: it is not the role of the board to have to prove to Judge Griffin's campaign that these votes were appropriately or inappropriately counted. It is the job of Judge Griffin's campaign to show that the votes shouldn't have been counted, and they have to have evidence. What they have is an affidavit by someone who is, by the terms of the affidavit, is someone who has some statistical background. That person's not here to testify. They're relying on documentation which does not necessarily prove what they say it proves. It is database. It doesn't show, for instance, someone can have a potential felony conviction but still be eligible to vote. We don't know whether this is accurate or not. There's no information that their information is not sufficient to be able to determine that. The standard, and we believe that this gets to the standard of review, which is they have an affirmative obligation to present evidence that these votes should not have been counted. That means affirmative proof. I don't think this affidavit does that. They've also challenged whether some votes were counted when someone was removed. Again, we think that they've misstated the burden there and also misconstrued what the process is for whether a vote counts when someone has registration is then subsequently removed. They've pointed to people who have cast votes and then subsequently their registration was removed. In those instances, the votes should count, although in subsequent elections that person would have to re-register to vote. So again, we would ask to be able to create a record here, to be able to take the board through the steps they took to verify the outcome of the election, to make sure that the votes that they were counted were appropriately counted, and that the challenge be dismissed. And that's what I have.
Can I be heard briefly on the notice issues? I didn't address that first time around.
Yeah, that's a procedural argument that's being made to you that the notice was defective as to the affected voters, and the ask is that there be a dismissal on that basis. So let's do here a little bit more of that on argument on that point.
Thank you. Justice Riggs' campaign suggests that we did not provide sufficient service or notice to the voters whose votes are being challenged. The statute and regulations do require that we serve notice of the protest on affected parties, including voters whose votes are challenged. But it doesn't say what that service has to look like. It doesn't say that we have to give them paper copies. It doesn't say that it has to be by a particular format or by certified mail, by U.S. mail at all. It simply doesn't say. It just says we have to serve them. Service means something very specific in the context of a lawsuit where you have a clerk of court and rules for summons, but those rules don't really apply here because this isn't a court proceeding. It's quasi-judicial, but it's not the same thing as being in superior court. What's the purpose of serving the voters? Well, the purpose is to give them notice. And I submit that our postcard notice did exactly that. It said, your vote is the subject of a challenge. Scan this QR code to find out more. We have received inquiries from voters who received that. And so, going to first principles, what's the purpose of that service? It's to give people notice that their rights might be affected. It did that, and that's really all that's required. At least that's our position, and we hope you'll agree with us. Happy to take any questions on that. Otherwise, we can proceed to whatever the county attorney thinks is next.
What's the,
And if I could just point out that the
Yeah.
service is, if you would have a copy of O2, there's a specific rule that deals with the service requirements, and that's what's being referred to.
Yeah.
It's 8 NC AC 020111 is the election protest form that deals with, and I think it's 0110, which also deals with service. And if I could just point to that, the affidavit part of that, this is affected parties in service, and this is in 0111. You must serve all copies of all filings on every person with a direct stake in the outcome of this protest. Affected parties includes every candidate seeking nomination or election in the protest, and it also includes all such voters and are such parties and must be served. It's unequivocal. It's not a postcard, it's all filings. And their postcard, which I don't have a physical copy of it, but I can show you a copy on my computer. It does not say that it just says may, it has the word may.
Yeah.
And so just to clarify the notice.
yeah, thanks. And where were you reading from?
So that is on, where it says affected parties in service under, it's 8 NCAC, and that's the 0111. And I believe you asked for copies
Yeah, I
of
did,
that.
and I'm looking at, so the first paragraph of 0111 says all persons bringing elected protest shall
Yes.
complete and timely file this following form. Is that the same thing you're reading from?
It is under the affected parties in service process part of the form.
Okay, and I'm just looking for that. Oh, affected party, you must serve filings in every person direct stake in the outcome, affected parties. Okay, so,
And I guess what we're saying is it doesn't say you have to serve physical copies.
right, okay. So just let's
Do we have a copy of that?
I asked for one late in the game because it was referenced in a letter we received this morning, so I'm going to read it to you, and then the director can make copies available. So,
Did you say you just received it this morning?
I received a letter this morning from Justice Riggs' team outlining their arguments against the protests, essentially, which mirrored what we heard at the podium just a few minutes ago. But I've just reviewed it this morning, so I did ask the director to make a copy of this form because this argument was mentioned in the letter. So let me just, for the board's sake, read what the regulation says, and then we can make sure everybody has a copy on this procedural question of whether or not the protest should essentially be dismissed for defective service. Okay, so 08 NCAC 020111 contains the election protest form. Okay, that's what the title of that regulation is. And the first paragraph says, all persons bringing an election protest under 15A shall complete and timely file the following form. For the purposes of this rule, timely means within the time of GS 163-182-9B. We talked about the time periods at the preliminary considerations meeting. Please note this form shall not be used to challenge registrations of individual voter or to report an incident other than irregularity affecting the outcome of an election. And then there's the form, and you're familiar with the form because these are the forms that were submitted to you that we went piece by piece through at the preliminary considerations meeting, matching the statutory requirements with the information submitted on the form, right? And so the argument by Justice Riggs' counsel is that in the form, there is an affected parties and service section listed on the form, which is contained in the regulation. And this is what it says. You must serve copies of all filings on every person with a direct stake in the outcome of the protest, the affected parties. Affected parties shall include every candidate seeking nomination in the election in the protested contest listed under Prompt 4, not only the apparent winner and runner-up. If a protest concerns the eligibility or ineligibility of particular voters, all such voters are affected parties and must be served. Address for information is available in the voter look-at. Materials may be served by personal delivery, transmittal through U.S. mail, or commercial carrier service to the affected person's mailing address or record on file with the County Board of Elections or the State Board, or by other means affirmably authorized by the affected party. If you know affected party is represented, blah, blah, blah. So that's what that says, right? And so what I would suggest to you is that we take that argument under advisement, the argument that the protest should be dismissed entirely based on failure of service. We move forward with each of the protests, and as you will with the other arguments before you during your deliberations, make a determination on whether or not there's anything to be done in terms of dismissal for failure of service. Does that make sense, Madam Chair?
Yes.
Okay. Very good. And we can, before we get there, we'll get copies of this for everyone to take a look at. All right, so with that, and one thing that I think is becoming apparent is that our elections director is going to give some testimony today. And so I believe it would be proper at this point, Madam Chair, to swear her in before she provides testimony.
Before we do that, can we query the audience to see if there are any voters or people who received notice of issues with their ballot?
Let's do. Is there anyone here, any voter who received information either from the Rockingham County Board of Elections? Okay, we have one. Sir, would you mind standing up and stating your name?
Douglas Palmer Jr.
Okay. And would you like to speak on the protest that includes a challenge, Mr. Palmer, to your vote?
If I may.
Okay, very good. So not right now.
Oh, okay.
Yep, not right, but keep standing because Mr. Palmer and the elections director, Ms. Seamster, will be sworn in. And so, Madam Chair, I believe it's proper if you swear in the witnesses, but I'll tell you what the oath is, and then you can repeat it, and then these folks can be sworn. All right.
Fine.
Yeah, come on up, Mr. Palmer.
Sir.
I'm sorry. Give me a second. Raise your right hand, please.
Yes, sir.
Don't do both at the same time?
Yeah, you can do them both at the same time. It's up to you.
Do you solemnly swear to tell the truth and nothing but the truth, so help you God?
Yes, sir. Oh, I do. Yes, I have it.
Okay. All right, so, Mr. Palmer, and I'm just going to look at the three protests. Okay, so you're on the list of felons with votes in Rockingham County.
Yes,
So
sir.
we're going to get to that one second.
Yes, sir.
So if you wouldn't mind, can you stay with us for a few minutes
Yes, sir.
this morning? Okay, great. And so we'll get you back up to the podium when we get to that protest.
Yes, sir.
Okay. Okay, so let's look at the first protest, which alleges that voters that were deceased as of Election Day but cast ballots in Rockingham County had their votes counted, right? So that's the first protest. As you heard from council, there's an affidavit attached to the protest concern that lists the voters that they allege were affected by dying between the time they cast their ballot and election day. So you see the affidavit listed in the protest of Mr. Bonifay.
That's right.
And then you have 1, 2, 3, 4, 5 voters listed there, right? Along with their dates of death and their vote date. So at this time, would the protester like to ask the elections director any questions about those
Certainly.
voters?
Ma'am, I'm afraid I don't know your name.
I'm Paula Seamster.
And I'm sorry, we have a small podium, and I know you have your hands full, and I apologize for that, but I want to make sure that we get everything, there's a microphone there. If that-
Understood.
if that's
Yes, it's important to make a record, yes. Ms. Seamster, I'm going to ask you a few questions about the 5 individuals on the deceased voter challenge. You have that list in front of you?
Yes, sir, I do.
Okay. And did Rockingham County undertake any efforts to retrieve the ballots of individuals who cast a ballot but then died before Elections Day?
We did.
Okay. And when did those efforts take place?
Prior to canvass, which was on October the 11th, and we removed 2 deceased.
Okay.
But they are not on this list.
I see. And when did Rockingham County compile its last list, or its most up-to-date list of deceased voters before beginning the canvass process?
I cannot answer that.
Okay.
My deputy director is the one that does that list,
Okay.
and she does that weekly,
Mhm.
but I do not know which day of the week she does that. The information I received would have been the day before canvass, which was on October the 10th.
I see. And what efforts did you or your deputy make to match names on the, actually withdrawn, where do you get the deceased voter information from?
It comes from the State Board of Elections maintenance list.
Okay. And do you do any like independent work to add names to that list or verify the names on that list?
Yes, we get information from our Register of Deeds office, and she also checks the DHHS list.
Okay. And what's the DHHS list?
It's the Department of Health and Human Services, or the state agency for.
And what information do you use for the Register of Deeds?
The Register of Deeds is the same information. We receive notification of who has passed away in the county, Rockingham County, from the Register of Deeds. We get that report on the 5th of each month.
Okay. And so that, in November, that would have been Elections Day?
Yes, that would have been.
And do you make any effort to try to, well, withdrawn, do the names on the list ever differ from one another?
Yes, they do.
Okay. And what do you do when that happens? How do you reconcile the different lists to figure out who's actually dead?
She looks for the actual obituaries to make sure that is correct. We check, sometimes we get information from the families as well, letting us know that their family member is deceased. But she goes through checking if we have the information for the Social Security numbers, the dates of birth, their maiden names, any information that we might be able to verify that this in fact is a voter in Rockingham County that has passed away.
Okay. And is there kind of a minimum number of amount of information or matches that you need to see in order to decide, yeah, we should challenge this voter or remove them from the list? From the
No.
voter rolls? Okay. It's a kind of a case-by-case judgment
It
call?
is, yes, sir.
Okay. And so I believe you testified that the 5 names on this list are not folks that were subject to a challenge during canvass, is that right?
That is correct.
Okay. And since you've received the protest, have you done any further follow-up research to determine if these individuals are actually
deceased voters?
We have.
Okay. And what were the results of those inquiries?
They were deceased prior to Election Day.
Okay. And so you're sitting here today, you have the opinion that these folks, their ballots ought to be retrieved from the canvas?
That is my opinion,
Okay.
not the board's, but my opinion.
Right. I see. All right.
I don't think I have any further questions on the first protest, if that's all right.
Very good.
The microphone, Phil.
Yeah.
Oh, I'm sorry.
And is it, okay, my scope is a little bit broader, just to provide some background on her role.
You can present your case how you like. What I'd say is we try to keep on track with the 3 different protests.
Right, I'm
try
just going to
keep it
focus
order.
on the questions regarding and I'm just trying to clarify. And again, what was your name again?
Paula Seamster, Seamster.
Okay. And this seems, what is your role with the?
I'm the Director of Elections,
And how long have you been in that role?
3.5 years.
And the 2024 general election, it was a presidential election?
It was, yes, sir.
Okay. And now, I know you said you've been in that role in the 3.5 years. Have you been at the County Board of Elections before that?
No,
Okay. Well, would you say, do you have experience with prior elections?
not presidential. This was
Okay.
my first presidential election.
Okay. Were there more people turning out for this election than in the other elections you were?
Yes, sir, there was.
Does that increase the amount of work the board has to do?
Yes, sir, it does.
Okay. So, and I'm just going to ask some general questions. What work do the county board staff have to do to send out, receive, and process absentee ballots in your county?
Daily, we received requests for absentee ballots, so they were sent out daily. There was a large amount that was sent out. But, I mean, it was more than what we've experienced before, but we had to mail them out daily.
Okay.
I'm not sure that answers.
And when you send them out, what work does the county board have to do when they receive the ballot back to review and approve the absentee ballots?
We have to make sure that they are eligible voters in Rockingham County and that they met the deadline of the registration.
Okay. And would they also have to review the contents of the envelope that was on it?
Yes.
Like to confirm their
Oh,
signatures?
when we receive those back, yes, we have to make sure that the voter signature's on there as well as 2 witnesses
Okay.
or a notary.
And there's also a requirement for a photo ID?
Yes.
Copy of that?
You either have to have your photo ID or a photo ID exception form.
Okay. And those have to be reviewed individually
Yes, sir.
before each vote is counted? Is that right?
Yes, well, and the board actually approves those at our absentee board meeting. Staff reviews and the Board of Elections also reviews.
Okay. And how much time is spent doing that?
It's a lot of time involved in that.
Okay. Can you be more specific than a lot of time?
It depends on how many come in. If we receive 5 in a day, it's not as much time, but usually it could be anywhere from 50 to 200 in a day.
Okay. And would that be a full day's work, or how many would you get through in a day?
It consumed one person's job for a day,
Okay,
yes.
okay. And what work did the county board have to do to conduct in-person early voting in your county?
That was a lot of work. Of course, we had to set up the laptops, get those ready to be sent out. We had to make sure that everyone that had registered prior to the deadline was in the system and that their voter registration cards had been mailed out. We were doing photo IDs. We were getting performing all the training for the different precincts and all of their officials. It's a lot of different things that is involved prior to an election and early voting.
Okay. Did you have to create a policy to deal with, for instance, a voter ID?
We did, and with the help of the State Board of Elections, yes, sir.
How many early voting sites did you guys have?
We have 4 early
Four.
voting
And
sites.
at each site, is there a chief judge?
There's a chief judge and 2 judges.
Okay, and they would have to have training as
Yes.
part of that? And so part of getting ready for the early voting sites would be providing training on this new voter ID law?
Yes, sir.
Okay. And for those ballots to be counted, they had to, when someone came in to vote, they would have to comply with either the voter ID or the exception law, is that right?
That is correct.
Okay. And so can you tell me what work the county board staff had to do on election day to conduct voting in your county?
It's done the same way as early voting. We have to make sure that all the ones from the absentees and the early voting, that information is transferred over to the laptops for election day to make sure that none of those could vote on election day for the voters. When a voter would show up on election day to vote, if they had already voted, it would say that their ballot had already been cast.
Okay.
So,
And so after, and so you're, on part of election days, you have to take all of the early votes and the absentee votes and get them to the places, the Board of Election, to make sure they're counted. Is that right?
correct.
Okay. And after Election Day, and I just want to clarify, I think you answered before that canvass was on October 10th?
11th.
It's
a Friday.
Was it on November?
I'm sorry. You're right. It's
Okay.
November. I'm sorry.
And so it was the Friday after Election Day?
Yes.
And that was, would that have been, and I think it was November, you're saying it was November 11th?
Yeah.
And I'd have to look at a
10,
calendar.
Me too, but it
Um,
was the Friday.
The
the
Friday following the
Yes, it's
Tuesday
10 days
election.
after.
Okay. And I'm
So
going
it
to
was
just
the
do,
15th.
I'm going to do us both, yes. I'm going to do us both a favor and look at my
Thank you.
calendar. November 15th, okay. And
right.
I'm just clarifying that. So in order to get ready for canvass, what does your staff have to do?
We're going through the records for same-day registrants, trying to verify that they do live in Rockingham County. We're also going through still receiving absentee ballots that have to be approved by the board. We're going through and trying to update voters' information in the system. We're mailing out the registration forms so that the voters have enough time to get those cards and verify that they do live where they live. We're required to get those voter registration cards out within 2 business days after a voter has voted. We usually receive that information the following day of early voting, and then election day, we receive it that night. But that's not same-day registrants. But it's a lot of research that is involved after early voting, and the ultimate goal is to finalize voter history, and that took a long time. Because what you're doing with voter history is making sure that the voters and the ballots that are cast equal.
And if I can just take you through some of that, and just to kind of help clarify. So for instance, someone who votes provisionally, maybe because there's no record of them registered or they were removed as of the day of voting, they would have until November 14th to cure that ballot, is that right?
That is correct, by 5 o'clock.
And you would have to mail out notices to any of those persons affected?
They receive that information when they vote.
Okay.
It prints out a form for them to review, and they are also told by the precinct official
Okay.
the information they're required to have back to this office.
Okay. But for those provisional ballots, there's no additional notice that you would send out?
That is correct.
Okay, so when you're talking about the additional notice, that's same-day registrants?
The same-day registrants.
And for those same-day registrants, what is the additional information that's?
It's a voter verification card that is mailed out, that they are asked to mail that back in with their signature and the date. Or they can actually bring it into our office.
How many of those were mailed out, do you think?
About 900
Okay.
or more, but at least 900.
And for those votes to be counted, you had to have received those cards back?
Well, if we receive the cards back as undeliverable, then we mail a second letter to the same-day registrant as a follow-up, just in case there was a mailing error or something that happened at the post office. But we send, it's two letters. It's a card first and then a letter that is mailed.
Okay.
And if we receive those letters back, then that's when the voter would have been removed.
Okay. And then, in order to complete the canvas, what work did you guys have to do? So you talked about all this work beforehand. And actually, before I say that, would you be able to estimate how many hours you guys spent preparing for canvas?
There's no way to estimate that. Very long hours. I mean, we have 10 days to get that completed, and you cannot get the job done in 8 hours. A
Okay.
day.
So how many people were working in the office?
During that time, we had about 7 people working.
And were they working the same hours as you?
No.
Okay. Well, do you know about how many hours you worked?
Madam Chair,
Yes.
you've taken us through the entire voting process. We're here with our immediate question has to do with deceased voters. Could you get to the point?
Sure, and I can just move on. I just have a couple more questions. Okay,
If you're going to talk about our general processes, yeah, I have an objection to that.
okay. Well, and I'll move on. Are you familiar with the results for the Associate Justice of the North Carolina Supreme Court race that we're here for today?
I know it was a very close race.
Okay, do you know what the results were in your county?
Not off the top of my head, no.
Okay. Are you familiar with the protest that's been filed?
Yes, I am.
Okay. And have you received a copy of it?
Yes, I
Okay.
am.
Do you have a copy of it there?
I do.
Okay. In that copy, there's an affidavit from Mr. Bonifay. Okay, and you have that. And Mr. Bonifay's affidavit, would you agree, just relies on what's reported at the State Board of Election?
On which page?
Okay, hold on just a second. I apologize. I believe it is page 9 of the entire document, but it may be
Okay.
on page 3 of his, or 2 and 3 of his affidavit.
No page numbers, Exhibit A.
What section number of the affidavit are you referring to? Maybe that'll get us there,
Yeah.
because it's numbered.
Yeah, sure.
The affidavit is numbered. In section 9, he talks about,
I believe we're looking at paragraph 10 on the affidavit. Is that right? Excuse me, it's page 8 and 9 and paragraph 12. Do you see where it says, that he attempted to match the State Board of Elections data?
Yes, I do.
Okay. And your office relies on 2 additional pieces of information that's not listed in that affidavit.
That is correct.
And those pieces of information are what you determined from the Register of Deeds office?
The Register of Deeds and the Department of Health and Human Services.
Okay. That's all the questions I have.
All right, anything else?
Not for me, thank you.
Okay, so anything else from anybody else out there on the first protest which concerns deceased voters? Okay. Very good. Board, do you
Board
have any
members.
questions?
Board
for-
members, do you have any questions?
I thought our first contact was from the state. From the state, we got a report back on deaths.
So what's your question? Are you asking a question, or?
I'm asking it of Paul. From our discussions that we had in our reviews, I was remembering that there were 3 points at which we had notification of deaths that we had to check and see if they voted in our county.
In this paperwork, and we've done that.
I just want to make sure I understand. Paul, are you saying that the 5 people listed on the protest did vote early and based on your information passed away before Election Day?
They voted early or absentee, yes.
Early or absentee?
That is
passed away
correct.
Before Election Day. Okay.
And were their votes counted?
They were counted.
So these are 5 votes that need to be taken out of the total?
That's my opinion.
Okay, and so I'll just mention, the state board has directed us,
Right.
because it's a multi-county election, what we're deciding is whether there is evidence of an irregularity or illegal voting, right? Which, and we don't have to go to the next steps and say whether or not it affected the election statewide, because we don't know. If this board finds that there is an irregularity, then we forward the names of the relevant voters onto the state board for further action. So that's just a little preview of what's to come with you. Okay, so any other questions on that first set?
I have a question. Paula, the names that are listed on the protest that they say are deceased, were they, I'm assuming you guys researched those.
We have researched those.
Okay, did they pass away before Election Day or after Election Day?
They passed away before Election Day.
So we are thinking that they probably sent in an absentee ballot before they passed away, or?
Yes, we had 2 that sent in absentee ballots, and of the other 3 voted in person, I think curbside, prior to their passing.
Question. Did we eliminate these from our count?
We did not.
Madam Chair, whenever you're ready to move on to the second protest about potential votes by felons.
Madam Chair, question
Yes.
for the attorney. Do we deal with each of these 3 independently, or do we deal with them collectively?
My recommendation is that you just wait and deal with them all at once so we get the arguments out of the way. But if you'd like to proceed in a different manner, it's really up to the board. If you feel, like it would be more expeditious or faster. But since we have an issue about the notice that would affect the protest generally, perhaps it makes sense to just wait and do them all at the end. That would be my recommendation.
Okay.
Okay.
Did you have another question?
Thought was that we're going to take the attorney's recommendation. That would be my thought. He's done this before.
Okay,
We're ready to
so
move on.
sticking with the principle that the protester has the burden, now we move to the second protest, which concerns potential votes by those with felony convictions.
Would you like to hear from Mr. Fallon first? Yes, Glasses, Jack.
Go ahead. I think the burden's on you, so
All right.
let's hear from you first.
All right. Ma'am, is it the policy of the Rockingham County Board of Elections staff to try to retrieve the ballots of individuals who incur a felony conviction before Election Day despite having cast a ballot?
Yes.
Okay. And what sources of data do you draw on to try to compile a list of felons that's up to date as of Election Day?
We have a maintenance list that we go by that comes from the Department of Corrections, and our deputy director reviews that and tries to make sure that those individuals are identified.
Okay. And how often is that list updated?
It's weekly.
Okay. And do you know if there's a particular day of the week that you receive it?
No, sir.
Okay. And so, let me ask you, have you seen the protest that Judge Griffin filed with related to felon voters?
Yes, sir.
Okay. And have you reviewed the names on that list?
Yes.
Okay. And are any of those names familiar to you?
No.
All right. Do you, did you or your staff perform any research in between Election Day and canvass with relation to these 8 individuals on this protest?
About these specific 8, I cannot answer that.
Okay.
But on felons in general, yes.
Okay. So were any of these 8 individuals the subject of a protest or a challenge, excuse me, in between Election Day and canvass?
No, sir.
Okay. Since receiving this protest, have you or your staff done any research on these individuals?
Yes.
Okay. And what kind of research did you do?
It's research with the felon completed list and with the DOC felon completed state matching list.
Okay. And what's the DOC?
The Department of Corrections.
Okay, so that's the prison system,
It
basically?
is, yes, sir.
Okay. And you know, what information were you looking for when you were making those comparisons?
Just trying to see if these individuals were listed.
Okay. And did you do any voter history research on these 8 individuals?
Yes.
Okay. And what was that research?
Just going through to see if any of them had been removed prior for convictions or whether they had moved out of the county. It's just like any other research that we do.
Okay. And were you able to determine if any of them had been previously removed for being found?
We had one.
Okay. And who was that?
The third one on the list.
Would that be Mr. Kevin Maurice Dickerson?
Yes.
Okay. And so, and as a result of that, was Mr. Dickerson's ballot removed from the canvass results for the county?
No, because we did not know why he was removed. There was no, the only thing we know is when he was registered, and the next thing we had was a change form. But as far as him having a felon conviction, we were not made aware of that until August.
I see. And what was the nature of the change form?
It was just a change form. I do not know. It could be address change, any of that.
Okay. And were you able to determine if Mr. Dickerson in fact cast a ballot in Rockingham County?
He did.
Okay. Did all the individuals on this list cast a ballot in Rockingham County?
They did.
Okay. And were you able to determine if the folks on this list had incurred felony convictions before Election Day?
Yes.
Okay. And can you generally summarize that research for us, and we can maybe do name by name if we need to?
Okay. The first one, we did find that he was on the felon list on October the 30th.
Okay.
And
And if I can interrupt you, when you say he was on the felon list as of October 30th, does that mean that's when his judgment of conviction was entered?
That was the report that we received,
So it was a report dated October 30th?
October 30th.
Okay, it doesn't necessarily tell you when the judgment of conviction was
That's
entered. Okay,
correct.
Thank you.
Director Sainster, can we just read their names?
Okay,
as-
so
as
I
we
didn't know
go?
if I could read names.
Yeah, no, I think we're going to have to
Okay.
name voters in our order.
So Walter Colby Carter, we had that he was on probation and he was on the felony list on October 30th of 2024. And just keep going. The Robert Paul, and
I don't know how to spell it either.
Um,
It's V-Y-A-N-A-N-E-K.
I'm not sure how you spell, is Junior, he was not found on the felon list that we have. The second one, Kevin Maurice Dickerson, we had that he was convicted on 8/24. He was on the felony report on October the 15th. Douglas W. Palmer Jr. was not on the felon list, but we found out that he was convicted on 8/30/24. We received that on the October 15th report. Johnny Ray Hopper, convicted 1/23. He was not found on the felon list. Simon Giannopoulos, he was convicted on 5/86. He completed his sentence and was discharged on August 24. Megan Faye Burchell, convicted 1/24, completed and discharged as of May of 2024.
Okay. And when you're withdrawn, when you're looking at the felon list provided by these other government agencies, does that reflect whether people have had their civil rights restored such that they're eligible to cast a ballot?
The only thing we have to go by is their discharge date.
Okay. And what's the significance of the discharge date to their voter eligibility?
The significance to us is they have completed their sentence and completed their probation.
I see. And so your testimony was that Ms. Burchell was discharged as of
5/24, let me see if there was an exact date. 5/15 of 2024.
Okay. And you weren't able to determine whether Ms. Burchell was convicted of a felony on November 2nd of this year?
We do have that as of 2023,
Of 2023.
November 2nd of 2023.
I see, thank you. And who were the, I'm sorry if I can just trouble you again, who were, what were the other names you indicated that have been discharged as of?
The second one was Simon Giannopoulos,
Okay.
and we have that as 8/24 of 2024.
Okay. So your testimony is Ms. Burchell and Mr. Giannopoulos were discharged and therefore eligible as of Election Day, and you testified you couldn't find Mr. Vahanik on any lists. Is that right? Any felon lists?
That's correct.
Okay,
That we have here, yes.
understood. But the other individuals, you were able to find a match between their voter registration and the felon lists?
We had 3 that we were not able to find on the felon list.
Okay, and give me those
That
names
was
again if you want.
the Melanie, Douglas Palmer, I'm sorry, let me go back. I've got that wrong. It's, yeah, Douglas Palmer, and then the last one is Johnny Ray Hopper.
Not a problem, please. On our sheet, we have verified. You have verified and then verification pending. What does that mean?
The verification pending is a card was actually mailed out
Okay.
and was waiting for that to come back.
Okay, the fact that you said that these people were not found on any list means what?
We had no way of knowing they were felons. Because we could not find them on our felon list.
Okay, we decided that if they were felons, they would be on somebody's list.
Yes.
And so, did you attempt to match NCID numbers between individuals on the felon list and the voter registration rolls?
I did not, but our deputy director does the maintenance list, and I'm sure she would do that the same way she would any other thing, try to make sure. But there were some that slipped through.
And would that have been part of the research efforts that she undertook after receiving this protest?
After and during.
After and during, okay.
Oh,
Do you,
I'm sorry.
go ahead.
Are there 8 names? Are there supposed to be 8 names on this list? Because the list we have only has 7.
It's 7.
Okay, somebody keeps saying 8.
I may have counted wrong, I'm sorry. Yes, 7, sorry.
Okay.
Thank you.
Can I direct your attention to paragraph 10 of Mr. Bonifay's affidavit relating to the ballot challenge?
Madam Chair, I have a question.
Okay,
I'll yield to the board member
All
if
right.
he wants to ask her a question.
To
Yeah.
attorney. The law has changed on felons. What is the responsibility of the felon upon completion of sentence and completion of service and pay bills, paying the responsibilities to be eligible to vote again? At one point is they had to re-register, and it has to change backwards and forwards.
Yep, and your director will know best what the process is, but the rights are restored upon completion, right? So they're eligible.
Yes.
Upon
Eligible to what?
To vote.
Or to re-register?
to vote. And then talk about the process.
Okay, once they have completed their sentence, and the sentence is their time served and probation, they are allowed to register to vote. The ones that had been removed due to felony convictions or whatever, most of these did same-day registrants. So they registered and voted the same day during early voting, the majority of it.
So, quote, the normal process may be to register and then eligible vote.
Yes,
Okay, but the registration is important.
registration is important, yes. They do
It
have
is- It
to,
is acceptable to register the day you want to vote.
yes.
I have a question. So, am I correct in assuming that these guys, or these names, or these people, registered and voted the same day, so their ballots would have been provisional?
Not all of them, and no, they would not have been provisional. If we were not made aware of any felony convictions. The Carter, Walter Kobe Carter, registered on August the 14th of 2023.
We don't have registration in the same day voting, correct?
Yes.
Um,
In early voting, you can register
okay, all
and
right, You're
vote.
talking early voting.
Um,
Okay.
The Robert Volnick registered and voted the same day, which was October the 23rd. Dickerson, Kevin Maurice Dickerson, he first registered on April the 12th of 2012. He did have a change form on October the 29th of 24. He had voter history from 16 and 18, where he actually voted. Palmer, we have a voter registration form dated September the 9th of 2024. Hopper, registered through the DMV on the last day of registration, which was October the 11th. And then Simon Geniopoulos and Megan Burchell. The first one registered on October the 29th, first time, and Burchell registered for the first time on November the 2nd of 2024.
Could you go through the list again and tell me how many of these people were felons on November 5 and were not eligible to vote?
The only ones I can tell you we knew were on the list, as in, well, we should have known, was Walter Colby Carter. Because the felon list, he was on the October 30th, 2024 felon list. Kevin Maurice Dickerson was on the October 15th, 2024 felon list.
So they did not get changed to reflect as a felon.
That is correct. But those were the two that should have been caught. We have 1, 2, 3 that was not on the felon list, and 2 that had been discharged prior to the November 5th voting day.
So that means that 5 of these, 2 of these voters, their ballots have to be removed. Is that your recommendation?
That's up to the board. I would say yes, 2 definitely, because we were not aware of 3 at all, and 2 of them had been discharged. So, yes, sir. The first and the third, which would have been Carter and Dickinson.
And if I may, ma'am, can I ask you to look at paragraph 10 of Mr. Bonifay's affidavit for this particular protest? And you'll notice that he says that in compiling this list, he relied on 2 kind of audit files produced by the State Board of Elections. One that's 2024 11-12 audited data that contains a tab felon with votes, and then another one that's appears to be dated November 7 audit data that also has records of felons with votes. I was going to ask you if those files were made available to Rockingham County as part of your efforts during canvass or during research efforts for this protest.
I'm not able to answer that.
Okay.
I did not view it personally.
Okay. And I take it you don't know whether other staff members view those?
Yes, our deputy director reviews the felony list.
Okay. And do you believe these are the same files that you receive as the felon list from the state board?
We receive lists monthly and weekly now. So, yes.
Sure. And I guess I'm asking whether you know if the state board's these audit files are the same or different as the felon list that you review in the ordinary course.
I don't know the answer to that.
Okay. That's all the questions I have for her. I suppose we should, before turning to Mr. Palmer, Justice Riggs' counsel should examine her.
Yeah, let's do that, and then we'll hear from Mr. Palmer.
Madam Chair, before we go to the next,
Yes,
we take a 5-minute break.
yes.
Thank you.
Now we can proceed.
Sure. And hopefully I'll just have a few questions. And I'm just trying to clarify the process. Most of your questions you answered before were about what you did when you received the complaint that was filed by Judge Griffin's campaign. We talked about the 7 voters that are listed, is that right?
Yes.
Okay. And so there, in the process of before you canvass the election, there are times when you see someone who voted who may have been a felon. Is that right?
They're supposed to be checked, yes.
Okay. And so when that happens, what notice do you provide to the person who's potentially a felon that voted?
I cannot answer that.
Okay. Do you think there's a postcard that's mailed to them?
I cannot answer that. I do not know. We have 3 people that work in here. We all have different responsibilities. This is an area that I have not participated in.
Do you know if that person's here today?
She is.
Do you know generally, can you answer some questions generally?
I'll do my best.
Okay. Is there an effort to verify that the person who's potentially listed as a felon was the actual person that cast the ballot?
Yes.
Okay. Would part of that effort be matching that with information that you have?
That is correct.
And so even if someone has a prior felon conviction, that does not necessarily mean that they voted inappropriately as a felon. Is that right?
That's correct.
Okay. And so if that came up, do you believe there is additional notice that is provided to this specific voter to inquire whether they were a felon or this is actually their felony conviction at the time?
There are felon letters that are mailed out, but what generates that or when they're sent out, I do not know the answer to that.
Okay. Would it be your presumption that those letters would be mailed out prior to canvass?
I would say that yes,
Okay. And so that would be the best policy
it would be.
and the best practice.
Yes,
And you want to have an office that has the best practice.
yes,
Okay. And so you would say it's important to make sure that you're not removing a vote where that person may not be may have been eligible to vote.
that is correct.
Okay. And then turning to this list that's been provided, the 7 voters that have been provided, had any of these, and you're saying prior to date, were these votes accepted by in the canvassing process?
Yes,
Okay. And out of those 7 people, only 2 of them appear to have been on a felon list.
to the best of my knowledge, yes.
Okay. And it is possible that they received a notice and they were eligible to vote at the time that the votes were cast.
There is a possibility.
Well, let me ask you this, so they could have, in terms of, I guess, the 2 people that were on there were, I guess it was Walter Kobe Carter. Is that right?
That is correct.
And what day did he register?
August the 14th of 2023.
Okay. And is it possible that this information with regard to this conviction may not be Walter Kobe Carter?
There's always that possibility.
Okay. So one way the board makes sure that a vote is appropriately counted is to provide notice, a felon letter that says your vote's not being counted to be because they're a felon. Is that right?
Right.
And have you seen the postcard that was sent to voters challenged by Judge Griffin?
I have not.
Okay. May I approach and show that to her? If you can just give me a second. and I'm going to show you, which is, I'm sorry, this is a copy of a notice that was sent out. Now, and I'm asking you to take a look at this. And is it okay if I ask questions here?
Can you pick him up?
Do you want me to turn this way? Okay, does that help you? And so, this,
May I suggest that you show whatever that is to opposing counsel as well?
and do you have a,
Is this the?
yeah, it's just
I'm
a,
familiar with the postcard.
okay.
And why don't you describe it so the board hasn't necessarily seen it? What is the, maybe you're going to get to that. Yeah, you're going
Well,
to what it is.
And I'll ask some questions about it, and hopefully that will help, but I'll be happy to show you the notes we're looking at, okay? And you can see on this one sent to a Miss Christine Riggs, it looks like. And it says, your vote may be affected and/or more,
You need to read it?
yeah, I'm not upside down.
Christine M. Riggs, your vote may be affected by one or more protests filed in relation to the 2024 general election.
Okay. Now, you said there's a felon letter,
We send out felon letters.
and
Yes.
what does that say specifically?
I can't.
Would it say, do you think it would say that your vote's
Well, this is felon letters that are sent all the time, not just during an election.
okay? And would that provide notice that they are if they voted, that their vote may not count because they're felons?
No, these letters actually say, according to our records, something to that effect. I don't know exactly that. It shows, our records show you are a convicted felon. Is this, in fact, the case, or something to that?
Okay. And you would agree this doesn't provide that same notice?
It just says one or more protests filed.
Yeah. And so if someone receives this, they may not know that, hey, your vote's being challenged because you have a potential, your record showed up as a potential felon.
Well, it does say, please scan this QR code to view the protest filing. So
Okay.
they can actually click on that.
They could click on that. Okay. If they have something to click on it
Right, if
with.
they do, right, that
You
is
would-
correct.
You might need like a computer or something.
Phone, something that can take a picture of that QR code.
Yeah. And has internet.
Yes,
Okay.
yes.
Do you want to show this to you guys?
We got it.
You got it, okay. And so, out of the 7 that were listed, you said only 2 appeared on a list that you had.
That our office has, yes, that is
Okay,
correct.
and what is that list from?
That is the Department of Corrections felon list and what we received from the state board's list maintenance.
Okay. And was that list, and
State
that list was maybe, was that a more accurate record of whether someone may be listed on the voting rolls and also have a felony conviction?
Yes,
Okay. And so for these 5 votes that are not on the list, it would appear that maybe they don't have felon convictions or they had their rights restored.
not sure. I mean, the last 2 are on the list, but they have a discharge date.
Okay. Which would mean that their rights were potentially restored.
Yes, sir.
And there's no information in the complaint that says their rights were not restored as of the time they voted.
That is correct.
Okay. And for the 2 that are listed, well, let me, actually, I'll withdraw that question. I think that's all I have.
Members of, if you have any questions, you can ask council.
Anybody have questions?
Madam Chair,
Okay.
my summary says we're looking at 7 names that were given to us. We found 2 of them that we could have and possibly should have caught, and they did vote, and their vote is currently still counting. That's 30% of this list. Is that a fair summary?
That is, yes, sir.
Okay, good.
Madam Chair, we had at the outset of the hearing, Mr. Palmer sworn in and said he would like to speak, and his name appears on this list, and he'd like to speak on this matter. Mr. Palmer, would like to come forward?
Sir.
If you will, just state your full name and just confirm that you were sworn in.
Yes, sir. My name is Douglas Palmer Jr. Was I wrong for voting as a convicted felon? And I did my time. I got bailed out. My dad bailed me out. But I don't think I get a letter to consider myself not to vote as a felon. If I'm wrong and if I'm off the list from voting, I won't vote until I'm eligible, to be back in voting. Am I wrong for voting?
I'm not going to, I don't know that the board can advise you of your rights. We can certainly talk to you about what the Constitution of North Carolina says about eligibility to vote. So it says that felons who haven't had their rights restored by completion of their sentence and all probation are not eligible to vote.
Oh, yes, sir. I'm still on probation.
On felony
I was on-
felony probation.
Yes, sir.
Okay, all right. And you may just, I think the best advice we can give Mr. Palmer, perhaps just to talk with a lawyer about that. Yeah, this board can't offer you any legal advice for sure, but.
Okay. Yes, sir.
But your information to the board is important and valuable. Does the board have any questions for?
I wasn't sure. I'm sorry, I did not hear his concern. Is he on probation and questioning, should he have been allowed to vote?
Right.
Yes, sir. Yeah, I was just wondering, if I'm not allowed to vote, I apologize for voting. If I went to vote.
You did attempt to vote?
Yes, sir. I went,
You did that.
I went to sign.
You did vote?
Yes, sir.
Okay.
Okay.
And I was convicted on, I think it was August. No, not August. It was August.
28.
Mr. Palmer, I don't think you have to explain all
Yeah.
that.
Yeah.
Oh, okay.
No.
Okay,
I was just,
let me say thank you for coming. We
Yes,
appreciate
thank you.
I'll second that. I thank you too.
yes, sir.
It's certainly helpful for the board to have the most information possible.
I just feel like I had to be here. I ain't wanna feel like being accused, excused from not being here. It's better to be here and know, to anybody that don't know me, I can show my face and y'all know who I am, my name and everything.
Thank you, sir.
Thank you.
Yes, sir.
Thank you.
Have a great day.
Y'all too. Y'all want me to, you will stay for the whole thing?
That's entirely up to you.
Can I ask just a couple questions, just so we got a real clear record?
Yes, sir.
Mr., and I don't know, maybe I should stand over here. You are Douglas Worthington Palmer Jr.?
Yes,
Is that
sir.
right? Okay.
Yes, sir.
And you're the same Douglas Worthington Palmer Jr. that was convicted of possession with intent to sell a controlled substance in 2023, is that right?
Yes, sir.
Okay. And that was a Class I felony?
Yes,
Correct?
sir.
Okay. And you said you're still on probation?
Yes, sir.
Okay. I appreciate your honesty and you being here today. Thank you, sir.
Yes, sir. Have a good day.
Thank you.
You too.
Thank you.
Thank you.
Okay, so we're concluding the evidentiary portion of protest number 2 concerning the protest filed alleging that felons voted and had their votes counted. Have any other questions on this one? And if not, we still have one more protest for your consideration. Whenever you're ready, Madam Chair. And again, this one says the basis for this protest is that the Board of Elections counted ballots cast by voters who had their registration denied or were therefore ineligible to vote in the election.
Good morning again, ma'am. Can you tell me about Rockingham County's process for doing list maintenance with respect to removing voters who failed address verification during the voter registration process?
Yes, we have a two-step process. First, within 2 business days, we send out a voter verification card. If we receive that back, then we send a second follow-up letter to that voter to see if that comes back. If those second letters come back undeliverable, then we remove those voters.
Okay. And is there a particular timeline by which that removal has to take place?
We're still doing it now.
And you're still doing it now with respect
Yes.
to the election on November 5th?
Yes.
Okay. Can you tell me about your list maintenance process for voters who have their registration removed for one reason or another?
It could be many reasons why it's removed, that we've been notified that they've moved outside of the county, they've been moved outside of the state. It could be the same-day registration cards being returned. It could be the voter registration cards that were updated that are returned to us. Again, we still try to send out a second notice. During this election, we did a letter. Normally, there is a second verification card that is sent out. During this election, if they received their card and the letter, both of those were returned undeliverable, then we were to remove them from the voter roll.
Okay. And someone who is removed from the voter rolls should not, their ballot should be retrieved during the canvass process, is that right?
That is correct.
Okay. You have to be registered on election day for your vote to count, right?
Yes.
Okay. What data sources do you rely on to, or withdraw? Do you draw on any data sources besides your own correspondence with voters in figuring out who those people are that have their registration returned as undeliverable?
We have list maintenance that we receive through the State Board of Elections. The State Board of Elections also performs list maintenance. Again, those verification cards being returned back to us undeliverable, or if their address says they have moved to a different area, then again, we send out that second notice, whether it is a card or a letter.
Okay. And does the state board send out notices of its own, or they just maintain the list?
I do not know if the State Board does that.
Okay. And so when you receive notice that like a voter has moved, for example, is that always coming from the state board?
No, it could be from the Postal Service.
Okay. Any other sources?
Just the Postal Service, State Board of Elections. We could also receive the voters calling, but we need verification from them that they are who they say they are.
Okay. And If I may ask, how was, if you said that this list maintenance is still ongoing, has Rockingham County completed its canvass for the election?
We have.
Okay, and you were able to do that despite having a number of registrations still up in the air?
I was directed by the state board.
I
Yes.
see. Do you know how many registrations are, I'll call them unsettled, but remain unsettled or pending verification despite the canvass being completed?
I do not.
Okay. Do you have a sense of whether it's 2 or 200 or 2,000?
I do not know the answer to that.
Okay. Have you had a chance to review the protest that Judge Griffin filed relating to voters who are not registered on Election Day?
Yes.
Okay. And have you or your staff done research on the names on this list?
Yes.
Okay. Can you tell us the results of that research?
Sure. With the first individual, Clifford Rue Swartz, the VRN number that y'all have, according to our records, those we had to merge. Those we had 2 in the system. And the number, well, I won't get that. But the VRN number that you have listed is incorrect.
Okay. So, what about, regardless of the VRN number,
Yeah.
were you able to tell whether Mr. Clifford Schwartz is validly registered in Rockingham County?
We have not.
So you don't know whether he's registered or not?
We have him as verified as being registered. We have not received anything back.
I see.
Okay.
So you understood. All right. And what about Ms. Danielle Leroy?
Danielle Leroy moved to Maryland and is living in an assisted living facility.
Okay. And was Ms. Leroy's, were you able to determine if Ms. Leroy cast a ballot?
Yes, she did.
Okay. And was,
Oh, I'm sorry. I'm skipped. That's Graves. Let me find Danielle Leroy. Let me back up.
all right.
I said
So
this
Ms.
incorrectly.
Ms. Leroy is not in an assisted living facility in Maryland?
No.
Okay.
All right, Danielle Leroy is the one that was merged, and you have the wrong voter registration number there. The Clifford Swartz did move out of Rockingham County on October the 18th of 2024. So if he moved to another county, they would have sent him back to Rockingham to vote, because you do have to have residency in that county for 30 days prior to Election Day.
I see. All right.
So that's Swartz. Danielle Leroy, like those 2 are the ones that were merged.
All right.
And as far as we know, she does still live here in the county.
Okay. So did you do any research to verify a residency?
We did not get a card back. So that's the only thing we have to verify. We didn't receive anything back undeliverable.
I see. Understood. All right. And you testified Ms. Helen Graves moved to Maryland? right?
Yes.
Okay. And was she removed from the voter registration rolls?
She is now.
Okay,
She
is
was
now.
not.
Okay. And when was, do you know when she was removed?
She was removed in September.
Okay. Were you able to determine if Ms. Graves cast a ballot?
She did.
Okay.
An
And-
absentee ballot.
All right. And since she was not registered, that ballot presumably should be retrieved, correct?
Correct.
Okay. Any reason it couldn't be retrieved, any logistical or tracking reason?
No.
Okay. What about Ms. Annie Frederick?
The first one listed, there was a staff error that actually, she's listed twice on this report. The first one is not her. There's another voter that her voter registration was attached to, and that was actually canceled prior to canvass, and the correct voter's vote was counted.
Okay, can you walk me through that again? So who's associated with whom?
The first Annie Hall Frederick, when we receive the information back during early voting, we have to scan that information into the system, okay, to match the voters. The wrong voter was attached to the Annie Hall Frederick file. So that had to be canceled, and the correct voter's information attached to the correct voter VRN.
Okay,
So that was staff error,
I see.
the first one.
And so, what about the second one?
Okay, the second one, we did receive a card back that it was undeliverable. The letter we have not received back as of yet.
I see.
And we have left the voicemail for her as well.
All right. Do you have any indication where she would have moved to?
Do not.
Okay. But you would have the address of record that you're sending the letters to, right? Or the
We
postcards
would
to?
be sending it to what's in our system, yes, sir.
Okay. And is that an address within Rockingham County?
It is.
Okay. All right. What about Gary Matthews?
Gary Matthews, we do have a copy of his obituary, that he passed away on October the 24th.
All right. And do you know if Mr. Matthews cast an absentee ballot before passing away?
He did.
Okay. And do you know whether that ballot was removed as part of the canvass process?
It was not removed.
Okay. I think it's your opinion it should be removed.
Yes, sir.
All right. What about James Matthews?
The same, we received we found an obituary where he passed away on October the 11th.
I see. And I take it Mr. Matthews cast a ballot before passing away?
He did,
Okay. And that ballot should be removed because he was not alive on election day, right?
in my opinion, yes.
What about Mr. Derek Lynn Anderson?
He still lives in Rockingham County, and I have his current address, and that has been verified through the GIS system with Rockingham County, and he does still live within Rockingham County, just at a different address.
I see. Okay. And how are you able to determine it's kind of the same Derek Anderson?
Calling and verifying his information that's in our system.
Okay. And did someone on your staff speak to him live?
Yes.
Understood. Okay. What about Ms. Barbara Crowder?
She actually lives at the address that is stated in our voter system, and that was verified by staff members here. And she is active, and her vote should have counted, and she still lives at that address.
All right. And did a member of your staff speak with her?
Yes.
Okay. All right. And can I direct your attention to the other list that was attached to the protest? So
Yes.
We can go through those names.
Yes.
Just for the record, Paula, you said you had obituary or death certificates for not only the voters on this list who is deceased, but
I had
also
the-
in
yes.
connection with the first protest, you had obituaries and/or death certificates for
That is
each of
correct.
those as well, that'll be part of the record, and you'll have an opportunity to look at those as well. Okay.
So were you or your staff able to perform research on the individuals listed on our protest as folks whose verification was returned undeliverable?
Yes,
Okay.
and we did receive their cards back undeliverable. We have not received their letters back. The second individual on the list, Ann Bailey Smith, works part of the year in the United States and the other part of the year in the United Kingdom. And how her ballot was sent was through the federal postcard application.
All right. So, were you able to speak to Ms. Smith?
No,
Okay.
have not.
Do you know whether she's in the US or the UK right now?
As far as I know, according to when she sent this in, she's still in the UK.
Okay. And would the address verification that you're sending the postcard and the letter to be addressed within Rockingham County?
It is.
Okay. When were the last batch of those second verification letters sent out?
As soon as we received their first card back.
Okay. And in Ms. Bailey's case, or Ms. Bailey Smith's case, do you know when that was?
October the 9th.
Okay. So the second letter would have gone out on
Either
about
the
October
same
10th.
day or the next day, depending on what day that fell on.
Okay. And that letter's not been returned undeliverable?
It has not,
All right.
as of
And-
yet.
And what about the other two folks on the list, Nicole Dallas and Dawson Stamey?
We have received their the first letters, cards back, but not the letter. And we did not have a telephone number on file for Nicole Dallas. And we left a message for Dawson Stamey,
I
but
think
have
Mr.
not
Stamey.
received that.
Okay. Can I get the
Can-
dates on which the postcards
Can we ask, obviously you are looking at a list and he's asking about something.
Yeah.
He's asking about individuals on the list. I just want to make sure that we're all on the same page here.
All right, this is the protest related to unregistered individuals, and I'm looking at the list that's labeled NC denied voters with votes Rockingham. It's got 3 names on it.
It's immediately behind attachment 1
Okay,
of the third protest.
all right. Thank you. What about that? Dallas, Smith, and Stanley.
So for Ms. Dallas, can you tell us when the initial postcard was returned to the elections office?
What is listed on here is November 5th, 2024.
So the second letter would have been sent about November 6th.
Yes, or the 5th, yeah. Depending on when, we usually get mail in the afternoon, so.
All right. And what about Dawson Stamey? When was his postcard returned? Let me ask.
I've got it. Let's see, Stamey's, Dawson Stamey. October the 14th, 2024.
Okay. And were you able to research whether all 3 of these individuals actually cast a ballot?
Yes, they did,
All 3 of them did?
yes.
Okay. And were you able to determine if they were on the voter registration rolls as of election day?
Yes, they were.
They were, okay. And is it your expectation that, or withdrawn, is it your experience that if a letter or postcard is going to be returned as undeliverable, it happens within a certain time period?
Yes, it
And
does.
what's that time period?
Usually within 5 to 10 days,
Okay.
depending on the postal service.
All right. I don't think I have any more questions. Thank you.
Yes.
Question for clarification, Paul. The 3 that's listed shows here that they did vote, but were not eligible.
Not necessarily.
Denied.
We don't know. We know that the middle one works, Ann Bailey Smith works here part of the year and part of the year in the United Kingdom. The other 2, their first verification cards were returned, but the second letter has not been returned.
the cards were returned, not received?
Undeliverable. Do you
But
want?
were they registered?
Yes,
They were registered and they did vote,
yes,
all three.
yes.
And one is potentially not, was valid. The other two is still in question.
No, I'm not saying that Ann Bailey Smith is invalid. I mean, because we have a lot of individuals that work in other countries part of the year.
So if they're registered, why were you sending them a letter?
Because we received their verification cards back undeliverable, and we're required to send a second form of notice, letting them know that, you know, we're verifying their registration. But these three were not same-day registrants.
But on November 5th, they were registered
Yes,
and they did vote.
they did.
Right, Bill. Hopefully so, and I'm just clarifying the process. So these are not same-day registrants that we're talking about. These are people who you might have to answer verbally. Like say yes or no.
Okay.
Yeah, so you're nodding your head, yes, they're not same-day registrants.
They are not same-day registrants.
And so, and the reason that you're having the simple verifications, they may be.
Change some information. Anytime someone changes their information, we have to update their information in the system, and we send out a voter registration card.
Okay. And are you familiar with North Carolina General Statute, Section 163-82.7G3? You know,
There's a lot of general
well,
statutes.
let me say, are you, so these are people whose registrations will potentially be removed if they don't verify their address, is that correct?
That is correct.
But under state law, would it be your understanding just because they may be removed doesn't mean they weren't, their vote should not be counted?
Correct.
Okay. In fact, under state law, that this vote, if they cast, does count, is that right?
Yes.
And that's for the three that we're talking about. The presumption under state law is that these votes should be counted.
Yes.
Okay.
Yes.
And that they'll be removed in subsequent elections.
Yes, that is correct.
Okay. And then on the second, and this was, the three we're talking about, Ms. Dallas, Ms. Smith, and Mr. Staney. Oops. That's on page 12. Those votes were accepted, and your understanding is they should count.
In my opinion, yes.
Okay, and then the second, and I'm just gonna, so we have, these are people who have been removed for different reasons, and we have two that you say are moved two moved from state, so moved away from the state of North Carolina, is that right?
Graves moved to Maryland.
Okay. And then Ms. Crowder, it says moved from state?
Ms. Crowder actually lives at the address that is in our system.
Okay, and so that's incorrect?
Yes,
Okay. But on that list, it says moved from state?
correct.
And that list was provided by Judge Griffin
Yes,
in the complaint. That's not the list the county operates.
right.
And then, I'm sorry, turn back. And the other is the duplicate for Danielle Louise Leroy, is that right?
There was two in there, those were merged, and only one vote was cast.
Okay, so one person, one vote.
That's correct.
And so it was just a duplicate, and so just
They
one
were-
registration became one
Yes.
Okay, 2 registrations became 1, okay. And then, the 2 that say move within state, that's Mr. Schwartz and Ms. Frederick, is that right?
That is correct. Mr. Swartz moved on October the 18th.
Okay. And that would be after October 6th? Is that,
Yes,
okay, and why is that important?
because it's 30 days prior to the election
And
date
where should he vote?
in Rockingham County.
And that's where he did vote?
Yes, it is.
And that vote should count?
Yes, it should.
And then the other one, I guess, was, we talked, was the Annie Frederick, the second Annie Frederick,
Yes,
is that right?
that is correct.
And it says moved within state,
Mhm.
and, but she lives in Rockingham County.
We have not been able to verify that one.
Okay. Now, again, she's not a same-day registrant, is that right?
That's correct.
And so, even if you can't verify, should this vote count?
It's hard to say that she has not moved, so yes,
Okay. Well, and if you don't know, you don't have additional information,
correct.
and she could have moved within the 30 days?
And she could have.
Yes, and so there's no information in Judge Griffin's protest that says this is an ineligible voter.
Right.
Okay.
It says she was removed on November 4th. That's the only thing.
And I'm sorry for pausing. And I think that's all the questions I have.
Board members, any questions for him?
No. I have a question for the director.
All right.
When did Ms. Leroy move, do you know?
Danielle Leroy did not move. Is that the one you're talking, the second one down?
Yes.
We do not have that she moved. They had her listed as a duplicate, but her files were merged into
When
one.
did she register?
That I do not know, I'd have to look. But it was not same-day registrant, so it was not during early voting. It was
She was
prior to.
registered.
She was already registered.
And I'm sorry, I lost my train of thought there. So she was properly registered on whenever she voted?
Yes,
All right. And you have no, well, this thing says removal date of 10/30/2024?
that, we did not remove her. We merged her two files to one.
Okay. And Ms. Graves, when did she register?
She has been registered, but according to our records, she was removed in September, on September the 27th, and that was when she moved to Maryland and is living in the assisted living facility.
Okay. So more than 30 days? has
It
passed.
is, yes.
And Annie Hall Frederick?
The first one was a staff error. It was supposed to be another individual that was listed there, but she is at the bottom, and we do not have any information that she actually moved.
All right,
within
so
the
she was
state.
properly registered?
Yes, she was
And
properly
eligible to
registered.
vote?
Yes.
Okay.
One vote was canceled, one vote counted.
Well, the top one was canceled because it was not her vote.
All right, and Anderson,
Anderson still lives in Rockingham County, just has a new address.
he was properly registered?
Yes.
Crowder,
Crowder still lives in Rockingham and still lives at the same address that we have on file.
properly registered?
Properly registered.
Okay. And going back to the short list, Dallas, Smith, and Stain, all were properly registered?
Yes. They were not same-day registrants. They were registered prior to election,
Okay,
the election starting.
thank you.
Okay.
Okay. All right. We'll wait, but just to summarize where you are in the process this afternoon, we can wait to move to deliberations. You've heard the arguments and presentation of the protesters' counsel and candidate Riggs' counsel.
Can I ask a question of Mr.
Marks.
Marks?
Certainly.
You indicated that you sent out this, was it a postcard
That's right.
with the, I have seen that.
Okay.
How many responses did you get from Rockingham County?
I don't know the answer to that, so I'm sorry.
Did you, in your research, determine how many households in Rockingham County do not have internet?
I don't know.
Let me kind of follow up on one point there. What is the protesters' understanding of the notice requirements to affected voters for a protest hearing?
I think our understanding is that the purpose of the regulation and the state board protest guides speak about service. The purpose of serving them is to put them on notice that their vote may be the subject of a challenge. I think it's because there's not detailed guidance on what format that needs to take. We mail these postcards. It directs them to a digital copy rather of the list with their name on it and the rationale for why they're being challenged. Candidly, given the compressed timeline that we have to operate under and the number of folks at issue, it would not have been logistically feasible for us to send everyone paper copies that's at issue. So we believe this is a creative solution that protects people's rights, that gives them fair notice of why they're being challenged. I think it's certainly small was here, but most folks, do have access to a smartphone. Certainly not everyone does. I don't dispute that, but it is sufficient notice under the circumstances.
Let me ask you this.
Certainly.
So, a voter receives this notice,
Right.
he has a cell phone, he clicks on the diagram,
Right. what
does he get?
I believe is going to be directed to the body or to a website that contains the files comprising the different protests. In other words, the stuff you have in front of you.
So a voter would receive, would be directed to another site.
Right. They would need. I believe they would need to click into the the files to look through.
So I wouldn't get a clear statement of what the protest is about as it affects me. I'd have to read through all of these 50-some pages.
I believe that's right, yes. It would not be personalized. It would, I believe everyone in the county would get the same documents.
I'm thinking through the argument about service and just trying to understand, so the board can consider it. The citation that was given for the argument that the service was insufficient was 08 NCAC 02-0111, which we're going to make copies of for everyone. And what I'm looking at is a regulation that talks about election protest, the election protest form. And it has certain required information. And within the form, it talks about effective parties in service. So, and I'm going to ask opposing counsel the same question. And then it talks about you must serve copies on each person with a direct stake in the outcome of the election. My question is, this regulation that speaks to what form is required, does the service section equate to a requirement for service to effect a valid protest? What would you say to that? Do you understand? Do you follow the question?
I take it the question is, do we have to send them something? I think the answer is yes.
Okay.
If the question is, does it have to be in a particular format as far as paper versus digital, I don't think it says that clearly one way or the other. And so, I mean, that's why we're trying to be practical here. Give people actual notice or a chance to view it without having to send paper copies to many thousands of people. That could be done logistically.
Okay.
Yeah.
So just to drill down a little bit further,
Sure.
So it is your understanding that even though this regulation speaks to the information that has to be submitted in terms of the form,
Right.
you do agree that this regulation requires notice to affected persons?
I believe it speaks to service.
Service,
Yeah,
so I must
functionally-
serve copies of
Right.
all filings on every person.
Right, but the purpose of service is notice.
Okay.
I mean, that's why we think the postcard method is adequate, because it puts people on notice.
Right, and then what about the second paragraph of that same section? So that's, you must serve copies of filings on every person, right? Filing conceivably would be the protest, right? I mean,
Right,
that's- Okay.
yeah.
And then the second paragraph says materials may be served by, and then it has particular methods of service.
Right.
Personal delivery, transmission through U.S. mail, and commercial. How do you differentiate or reconcile the materials that may be served by one of those particular methods and the filings?
Sure, I mean, the filings are available, through the QR code. It does use a different word, which would suggest that maybe it means something different. But again, the purpose is to give people functional notice, and so we think we did that. I mean, the statute doesn't specifically say it has to be in print. I mean, you can imagine some kind of, crazy examples. If we print the whole protest in teeny tiny font and put it on a postcard, would that put people on notice? No, better to do what we did than that. So I think it has to be judged by a practical standard of whether people actually had a chance to get the materials that were affected, that potentially affect the rights.
Okay.
Yeah.
But actual notice means that you're going to tell me what's wrong with my vote. And you don't do that. But you
Well,
limit to 55 pages that I will argue for the sake of this hearing, most laymen would not read. And even if they did, they wouldn't understand all the jargon that's in here.
So I don't think there's a warrant in the statute, the regulations, or the state board's election protest guide to say that, it has to be personalized, right? I mean, people commonly receive legal notices in the mail that are hard to read and hard to understand. They're still kind of charged with knowing what's in there, right? Class action notices, for example, right? I mean, the question is, did they have a chance, or not did they read it, but did they have a chance to read it and learn about it? I mean, that's, that people's rights are affected by, obtuse legal notices in the mail all the time. I'm not saying our notice was obtuse, but even if it was, I think that would still be okay, because that's not a common, unfortunately, so.
Thank you.
All right, thanks.
I'm going to put the same question to you, just because I said I would, and that is, do you believe that the affected parties in service section of 08 NCAC 020111, even though it's just talking about what form is required, is that sort of a prescriptive service requirement in this process?
So I think it's important to keep in mind the context we're talking about.
Maybe come forward. I just want to make sure you're going to be picked up.
I'm sure you guys love hearing lawyers talk. So the context is we're challenging these people's constitutional right to vote in the state election. So that's the context. This is not a small right. It's not a class action where you're owed $1.95 maybe because you were overcharged by some point. And those notices have a lot of information about the parties that are involved and what exactly is needed in the document that's sent to respond. And that's not what's here. And you talked about it. What happens when you click on that site? You go to the NCGOP page. If you click on it on your phones, get the QR code. If you have internet access to this building, what does it get you? It doesn't get you the filings. It gets you a page of the NCOG list of challenges. It's no information with respect to that individual voter that's immediately available in the code. They have the address to send it. They go by in the filings. There's no information in that card that says even unequivocally that this is a challenge to your constitutional right to cast a ballot. And that's what's going on.
May I back you up?
Sure.
What happens when you click on that?
So if you click on that page, and I left my phone.
I've actually got one if you want to pass it around.
Yeah, and it takes you to what is listed as Election Protest 2024. That's what it takes you to. And if you scroll down, it says more information, we'll hold a hearing, and it has the names of, presumably, all the counties. So, this is not, sure.
Please go ahead. I know you didn't do this, but if you click down to Rockingham County, what do you get?
Well, let's see what you get. You get 4 categories: incomplete registration, felon voters, deceased voters, not registered voters.
But nothing in that says that you're talking to Thurman Hampton about his vote.
Right.
Okay.
Well, what happens if you click on one of those links?
Well, you do get to it eventually, right? But you don't get to it as the rule requires.
But you get to a list of names.
You get to the documents that were sent to the protest here. But those documents,
Which would be similar to this information.
it is that information.
It is this information.
It is that filings that were
And that
sent.
information is compiled by,
That is the protest that Judge Griffin filed.
the original information came from where?
In this document, that is their protest.
I thought it came from state board,
Um,
data from the state board.
Some of the information which has not been authenticated is from the state board website. That is true. But this is documentation information that y'all went through, that you've heard about the canvassing process. This was a process that you went through to make sure these votes should have counted when you counted them on November 15th. And so we would just ask that, and then, again, he's talked about it's equivocal, it's unclear all the time. Legal notice is unclear, and we get these weird things. This is, you never get a postcard in the mail that says, you might have a problem. We're not gonna tell you what it is. They could add another sentence at the very least, they did not. They made it purposely hard to get to.
Thank you. You answered my questions, both of you. I appreciate that. Okay, so where you are in the process is you've heard argument and the cases of the protester and the challenger here, and you have all three protests before you, and you have a request for dismissal based on lack of service that I think we have to address, as the board has to address one way or another as a sort of a threshold issue to move on. The usually, procedural questions can be addressed by the chair, and then if you'd like to have input from the board members, you can, but a lot of times the chair makes a determination on, procedural questions, like dismissals. But the board can also weigh in on that if you prefer. So you've heard the arguments, and I'm happy to give you my take on the technical legal service question, if you'd like it. But I think that's sort of a threshold question for you to get through. Should these cases be dismissed for defective services or not? And then you have the merits of the case, and you've certainly heard from the director her opinion about some of those voters who have passed away. So maybe the thing to do, especially as to the service issue, because I don't know how you would affect service on a deceased individual necessarily, right? So perhaps that's different, right? That one is different. That protest is different. So, I think you could deal with that one if you wanted to, independent of the service question, because it's irrelevant in a way, how you affect service on a deceased individual. They couldn't have received it in any event, right?
Explain, if you would, explain what you mean by service. What is the service that wasn't rendered or should have been rendered?
Right. So, and Paula, can we make a copy of this before we get much further? Just want y'all to be able to look at the same thing that I'm looking at. So there's a regulation that we've been talking back and forth about and hearing about. And the regulation speaks to what the form of the protest must take, what must be included in the protest. And there's a section of the regulation that talks about service. And so what I was trying to get at is, one, does this regulation mean that you have to do what it says in this regulation in order to have a valid protest? Because quite frankly, it's not clear to me. And so that was the question that I was asking. And then the question becomes, okay, and it sounds like both council agreed that there needed to be some service, just a question about what the service requirement is. And I think the best way for the board to make a decision on this issue is to look at the language and decide for yourself. And I'm happy to give you my input as we go along. But my questions were, when you see the regulation, I think you'll understand where my questions were coming from, or at least maybe I can do a better job explaining to you why I was asking what I was asking, because it talks about the form. It doesn't say, the regulation doesn't say itself, outside of the requirement that you have this form, that you have to do X, Y, and Z to affect proper service of a protest. It's not that clear.
The statute mandates that the state board, develop this form
That's right.
and this information. So it's not something that the state board just dreamed up.
No. They were required to do it, and this is what they developed as the required form.
You might explain what the administrative code is.
Yes. So there's a hierarchy of authority when you're talking about legal authority within the federal system and the state system. You start with the Constitution of the United States, and then you move to the North Carolina Constitution, and then you move to state statute. And by statute, the statutes can't address every situation. And so a lot of times, the statute will direct an agency to develop rules that guide a certain process. And in this case, North Carolina general statutes direct the State Board of Elections to develop certain processes for things like protest hearings, right? And so when we're talking about NCAC, that's a citation to the North Carolina Administrative Code. And so the state has directed the Board of Elections to develop certain rules and processes for protest hearings, and they've done, and the state board has done that, and that rulemaking process is a vetted process. It has to go through public hearings and that sort of thing. So once the administrative code regulations are adopted, they're binding, right? They're binding authority, and as required by statute, created. And so in this case, what we're talking about is 08 NCAC 020111, which, as you see at the top, is titled Election Protest Form. And this is the form that the state board has developed for protests that are filed under North Carolina General Statute 163 182.9C, right? And you'll remember in our preliminary considerations meeting, you were tasked with determining if the protest contained the required information by statute, right? And they used this form which had the required information. So turn to, relevant to the discussion about service, is section 13 of the form, which appears on page 3 of the regulation. It's actually just below section 13. I guess it's part of section 13. No, I'm staying corrected. It's part of it. There's a check the box. Have you received any financial other benefit or promise? And then the next thing you see there in 13 is affected parties and service, right? And so I'll, read that loud because that's just the way that my brain works. You must serve copies. This is talking about the protester. Again, this is the form the protester must file. Does everyone see where I'm reading? On page 3, section 13. You must serve copies of all filings on every person with a direct stake in the outcome of the protest. Quote, affected parties, right? Those are the affected parties. Affected parties include every candidate seeking nomination, of election in the protested contest, right? If a protest concerns the eligibility or ineligibility of particular voters, like we have in this case, all voters are effective parties and must be served, okay? And then address information for registered voters is listed. So again, the first sentence, you must serve copies of all filings on every affected person, and I think both parties here today agree that the voters listed in the protests are affected persons that must receive service. So what you've heard is that there was mailings of a postcard to the voters that contained this QR code, which got you eventually to the link. As you see this language, and then it goes on. The second paragraph talks about materials may be served by personal delivery, transmittal through mail, or commercial service. And I don't know that there's no distinction between, well, there is. The first paragraph talks about filings, which would be the protests. The second paragraph speaks to materials. So we're talking about the protest filings themselves in the first paragraph there. But it doesn't give any more guidance. The regulation doesn't provide any more guidance about what you have to provide other than the filings or how you do it. And you contrast that with the rules that we followed, the board had to follow in noticing the hearings, which are much more specific about what we had to give and who we had to give it to, and how how we were to deliver it. So there's just not a lot here, I guess is my point.
The form also asks for service address for those who are to receive notice. Looking at the list that we received, none of these lists show service address for any of the voters.
Yeah, and I don't know what there was an affidavit of service filed with the protests. We can look at that. So on November 22nd, 2024, Philip Thomas filed on behalf of the protester an affidavit regarding timely submission and service of election protests in accordance with 08 NCAC 020111. And that should be, Paul, is this in their packets as well?
Yes.
You have a copy of this.
If I may, there's also an affidavit from Kyle Offerman that should be part of the packet.
And I believe we have both of those, but we can take them in turn. So there was a November 22nd, 2024 cover letter that speaks to service, and it has attached to it an affidavit of Kyle Offerman. And I will refrain from reading out loud, even though that's mine. I read to myself half the day, it seems like, but I won't do that to you.
Mr. Farrell, the real question is here, did we let the people know who were affected, that they were going to potentially be affected by our decision?
We certainly did, and the director can speak to the efforts that we made of notice of the hearing, right? Of the hearing.
And that's probably where Mr. Palmer got his information and came here and shared with us what he got.
And I don't know the answer to that, and I didn't think to ask him that when he was here. I don't know, I don't believe he said one way or the other, to my recollection. But what did we, you can talk about what we did or the board did for this notice of the hearing.
But it's not our obligation.
That's right, it's different. It's different, and maybe that's irrelevant to your discussion. But if you wanted to know, the chair can tell you.
Did you send that, is it often?
Yes, sir.
Did you send that in email last week? I think I read it, but I can't find it.
It should be at their place. The affidavit, the November 22nd, 2024 cover letter.
I thought it was, but I'm not finding it myself.
Oh, you're not, okay.
I thought it was. but-
Yeah,
You gave us a copy of the list of the people who served notice.
Yes,
That was the notice of this meeting.
yes.
Yeah.
yeah, but what I was speaking of is an affidavit that the protester filed about service of process with the Board of Elections. And so
Yeah,
we can make a copy just so
Yes.
you have that.
it's a lot of paperwork here.
Yes, there is a lot to compile, but we can make that, I've got it.
All right,
All
let
of-
me just make it just in case. Is-
That's okay with those council.
This?
Yeah, that's the same thing. Yeah, let's make a copy of that.
Yes.
available. And do you have a copy of that?
I think I did.
Okay, Paul, can you make
This
one
is-
extra? Yeah.
of service from the Director of Elections.
That is the notice of hearing. That's
Notice
not.
of our hearings here.
Today.
But at the meeting we had last week, whatever it was, we approved that the petition was legitimate and that we felt that there was grounds that it might be significant or that it might be an issue. But now we're questioning whether or not it was what we did last week, what we approved last week with a motion to have this hearing was appropriate.
I don't think that's technically correct. I think what we had to do at the preliminary consideration was judge whether the protest form met the requirements of statute, whether the information submitted met the requirements for submission of the protest, right? And at that time, we were directed not to take any evidence, right? We couldn't look at anything outside of the paper itself. And we didn't entertain any argument about service, which is actually I think an evidentiary legal question. So I don't think that your preliminary consideration is necessarily relevant to the question before you today. I think that was what you did there is separate from the question before you today on whether or not the protest form
But
was
am I
sufficient.
wrong? We actually went through the process last week saying, before we even agreed to have this hearing, that the requirements were met for us to move forward with the protest.
What we did is at the preliminary consideration hearing, we went through and established that the protest included the information required by statute.
So what are we questioning now?
So the question is whether the protest itself was served properly. Yeah, that's right. That's the question that Justice Riggs had, that's the argument they advanced, that it wasn't properly served. And therefore, presumably all of the protests, they didn't distinguish between the deceased voter and the other voter. So, to extend the argument they made, if the service was defective, it would be defective as to all the protests. They didn't distinguish between services to protest 2 and 3. I don't know if they would or not, but they didn't. So conceivably, if you accept their argument, all the protests should be dismissed.
Yeah, but the statement that we just read prior to this discussion doesn't give you any specific direction on how the information should be served. It just says it needs to be served.
And the counter argument that you've heard is that, and this affidavit that's coming around now says, we did comply, right? We did comply, and this is how we complied. This is what we did to effect service. And so that one argument is they didn't do what they had to do under this administrative code provision, right? That's Justice Riggs' position. And of course, the protester says, no, in fact, we did. We did do what we had to do, and this is why, and the affidavit lays that out, and you also heard argument of counsel on that point.
Quick question. The election was November 5. What was the filing deadline for the protest?
Let's see what the statute said about it. It was within 2 days, I believe it was within 2 days of the canvass, but I can get that for you.
4:57.
And we got it
Was when we received the notification on the last
like
day.
3 minutes.
Yeah.
Okay. If the protest, so I'm reading from 163, 182.9, filing an election protest, and subsection B4C says, if the protest concerns an irregularity other than vote counting or election or result tabulation, which is the case with all of 3 of these, the protest shall be filed no later than 5 p.m. on the second business day after the county board has completed the canvass.
And we went through this document last week where they said how they notified the individuals.
Well, whether, one of the things we looked at is whether it was timely filed as to the county, right? And that was the job of this board at the preliminary considerations meeting. And you heard from the elections director at that time, she received the protest at something like 4:57 on the second business day.
Right.
At the preliminary meeting, we had to determine whether the protest substantially complied with GS 163, 182.9, which had the information that was required, and we can look at that again if you want, but we did that and decided yes, it did, and whether it establishes probable cause to believe that election law, that was taken out of our accounts, right? And one of the items of 163, 182.9 is timeliness, right? And as to timeliness, it says the protest shall be filed no later than 5 p.m. on the second business day after the county board has completed the canvass. So having the information that we had at the time, you made those affirmative findings, which is now why we find ourselves here today. So if, again, just to reiterate, and we can go through the arguments again, the administrative code provisions again, if you want to. But what the board will have to decide, and the chair, you can determine how you'd like to proceed with that determination, is whether or not the motion to dismiss should be granted for failure of service, right, according to the administrative code provision. And if that's the case, it would dismiss all of the protests, conceivably. And if not, then the job is just to move forward with the evidence that you've been presented and the testimony of your elections director, and determine if there has been substantial evidence presented to this board of an irregularity or misconduct that impacted the election results, or that could impact the election results on a statewide basis. And again, because of the posture of the statewide account, what we really need to determine is whether or not there is substantial evidence of irregularity in Rockingham County for one or more voters. And if so, you forward that information on to the state board. So we're not removing any votes today, right? That's not within your purview. You're not canceling any votes today. You're just determining if there's substantial evidence presented in the record of an irregularity or misconduct that could impact the election results.
So the question in my mind is, what is what did this not do that the state law says we should do?
Right, well, again...
And it could have been a whole lot better, but I hate these RQ codes. I don't like those things at all. And then you had to go through 3 or 4 lists to find out that I was the affected party. I'd have given up on about the third one.
Well, and I believe the affidavit indicates that they didn't send these cards to everyone in Rockingham County, right? They sent them, let's look at what the affidavit said about who got what. And now I'm
understood from these lists.
Right, right, I think that's right. So let's just go back and see.
They sent it to those lists, and they could go back, if they were willing to go through 3 or 4 levels, they could find their name, and then they could get upset, and then they could protest.
Yeah, we compile, this is what the affidavit says about service. We compiled an Excel file containing the names and addresses of those parties affected by the protests. And to ensure conformity, created a web page, QR code, service postcard to the affected party, so they mailed to these people on our.
It could have done a lot better, but I don't see anything in the legal standings that says that isn't appropriate. Or that says that this is the best way to do it, or this is the right way to do it.
Yeah, that part of it's very vague.
Yeah, again, just the
That
language.
was approved by the state board, as I understood from our earlier conversations.
This is the form out in the relevant regulation on which protests have to be filed.
If the chair decides that we are to deliberate on this issue, do we go into closed session?
I generally don't favor closed session and deliberations. I'm happy to offer you, my view. But if you have a question that would impact the attorney-client privilege, right, which is your privilege, it is possible to go into a closed session to consult with a lawyer in order to obtain privileged, confidential legal advice. My general bent, because all deliberations have to be done in open session in a hearing like this, is to stay in open session to the extent we can. But if there's particular legal advice that you want that's protected by the attorney-client privilege, it's your privilege, you own it. You get to decide if you'd like to go into closed session and receive it. My bent is to limit closed sessions. I think I'll just stop there. If you have questions of me that I can answer, I will, in open session, I will do that. But again, it's your privilege, and you own the privilege to the advice that I offer you.
But I do have a question to the board members. Do you think that the service was clear?
That's what.
Was it clear? Was it the gentleman that came in here, he came in asking questions because he wasn't clear on whether he made a mistake in voting. We have about 17 names on here that were sent. And, we're not sure how many came back to the office that sent out the information. I don't think we were told if any were returned.
Paula,
So,
what was the return address on the letter that was sent out? Was it this location?
Oh, I wasn't required, but I did send it. But are you asking, was any of ours returned?
no, you've already gone through
Okay.
what was returned from you.
Okay.
I think my question is asking the individuals with the list, addresses that were sent out from the plaintiff. I'm asking, did you get anything returned?
I didn't hear the response. Did we get any response back on the letters that we sent out? So we got no response on what we sent out advising of this meeting.
Right.
No responses, no returns.
Right, ma'am. I can't say, I don't personally know about that kind of beyond what's in Mr. Offerman's affidavit. So I can't really testify to that, based on my own observation. Yeah. Sorry.
The value I would put on this, if I were on the list, would I be happy with the way I was notified? And I would have to say I'm not.
Right.
And the second question is, where did they violate the rules in not sending it out in more detail about me? so I can do something about it. If I got a list with, 50 names on it, I may not even read through that. I may not even get to it, because I've got to go through 4 different levels to even get to that. And I don't think it's a well-designed system, but it doesn't seem to not meet the state requirements.
What's your take on it?
Right, I think what you've heard is all you have to go on, which in my view is not very helpful. And that's where you find yourselves trying to read this first sentence. You must serve copies of all filings, right? And it doesn't tell you how to go about, and probably doesn't say do it in compliance with Rule 4 of the North Carolina Rules of Civil Procedure. It doesn't say you have to send email or the best method possible given the very compressed time frame for these. That's all you have to go on, is you must serve copies of all filings on every person with a direct stake in the outcome. And then it goes on to talk about how materials may be served, but that's not the filing, that's not necessarily the protest. And I don't know that there were any other materials other than the affidavits, which are filings in the matter. So, yeah, I just don't think there's a lot here. And I think, given the vagueness, right, it's a difficult to say, well, you didn't comply because you sent this postcard, right? There's something sent. But it's also very difficult and opaque to figure out why you're getting it, right? So I think that the challengers have forwarded this argument in every protest all across the state. My guess is county boards like you, I think there's, what do we hear, 25 or 26 of them are being held today, are wrestling with these same questions. And ultimately, the state board's going to end up with an appeal on this question, I bet, one way or the other. And so I think the way that I would suggest that you look at it today is make a decision on it, and however you decide, still move forward on the evidentiary questions for you. It's sort of in the alternative, because this question is going to be decided by the state board ultimately, and we'll either have to, and if the state says, nah, this was enough, this is what the administrative code requires, service was okay, right? Then we got to get back together and do the evidentiary portion again. So in order to avoid that, I think we make you, the chair, or however you want to decide, make a decision on this threshold question. And then no matter what you decide, go on with the evidentiary portion, which would be irrelevant, right, if they're dismissed, but you could still have a record of what you would have decided had they not been dismissed. Do you understand what I'm saying?
I do.
Yeah.
Put this in the context of the statute. If we determine that service was insufficient,
Right.
that is the same as saying, or is that the same as saying that the board finds that the protest does not substantially comply with GS 163 182.9?
I don't think so, because the service provision in the, I don't think that's necessarily the same thing. I think it's saying, because we didn't have an argument about service at the preliminary considerations meeting. This is the first time, and we weren't to take any evidence or argument at that hearing as directed by the state board. So this is the first time that I think that the service issue is properly before you.
I'm looking at the conclusions of law. 163, 182, 10. I'm sorry, 9.
I'm sorry.
I guess my question is, how do you put, well, never mind. Let me ask one other thing. Typically, in all in legal filings, words like must indicates that whatever it's talking about has to be complied with. Must, shall, you gotta do.
I agree.
Okay.
You must serve copies. And that was the bigger picture question that I had on this regulation to begin with, right? It is a form, right? It's not a service requirement. It's not an administrative code section that talks about these are the service requirements for protests, right? It is a form, a regulation that creates the form. And so, but both council agreed that yes, in fact, they think that service should be done according to this form. So that they both agreed on that, and so I'm not sure, but since they were both on the same page about it, perhaps we can just take that as
It's the only form that they.
for what it is. That's right. It's the form available. It's the information available. So it just, again, you must serve copies of filings on every person. And what the evidence is in the affidavits is they served it by these postcards that had links to the information. That's what they did. Is that adequate? Does that satisfy the administrative code provision? That's the question that has to be answered by this board. And by boards all across the state, quite frankly, that are being presented with the same question today. And ultimately by the state board as well. Because they, as you know, retain jurisdiction over a good number of these protests in the first instance, right? So we had 4. 1, they've got, and presumably they're going to make their own decision, and whatever they decide, ultimately, right, because they're the appellate body to this body, will control. And that's what I'm saying. That's why I'm suggesting, make your decision, whatever it is, and then move on to consider the protests. Otherwise, we may very well have to do this all again in 2 days.
I recommend dismissal.
Dismissal, no matter what the evidence was of the other case, of the
And
individual
we're going to
cases.
move forward with looking at additional information just in case it comes back to us.
Madam Chair, I feel differently. If we could point out specifically where the requirements were not met, then I think we should throw the thing out.
And we can't do that.
But I don't think we can do that because I think we've said before that the rules were followed. Now, the next step is then what do we do with these 3 individual issues where we've got 7 of them and only 2 took someone's vote away. And another one where there was 9 and only 2 or 3 took votes away. I'd like to make a motion, Madam Chair.
Just a minute.
Sure.
I think the point you made earlier about this being a not very good process
And he's contradicting that.
means that, well, I agree with the chair, I think this should be dismissed simply because notice is insufficient. I'm motivated by the fact that the regulation itself, the form, says you must serve copies. Must. Not maybe, but must. And frankly, we're like a number of other counties in the state. We're sometimes very rural, very old. Not everybody in this county has a smartphone or even an internet connection. And even if you do, what you get is a referral to another site and then another site. I don't know how many of you have websites like Amazon or AT&T, but they're terms of service. I'm sure you've all read those, right?
Send you around the world.
There you go. That's what I think this process ultimately does, is force the voter to go into one site and dig deeper and deeper. When I see must give notice, I'm thinking that you gotta tell me what's wrong with my vote specifically. I agree with Brian, we should go forward with the other, the evidentiary hearing and the other, just to make sure that we've covered ourselves on that, so we don't end up coming back here again. Not that I object to seeing y'all, but, again, I just feel like the service in this instance, and I understand the time pressures, understand how many pages this is about, and how you might have been affected by the fact that you had to mail this protest to probably every county. But still, looking at it from the standpoint of like one of the voters who came here, you haven't told me exactly what I have done wrong or might have done wrong. And I think that's what notice is about. So,
Well, I agree, and I'll repeat myself, I think it's a very poor way to do it. But I don't see it crossing over the rules. If I read through the rules, I don't see it crossing over the rules saying he did something that wasn't legal.
Even when it says we must serve notice or copies,
They did serve a notice.
they don't say how you should serve it. They don't give you a specific way to serve it.
well, it does say copies.
All up to
Postcard with the
interpretation.
QR code is not a copy.
All up to interpretation.
Well, okay.
Sure don't.
I'm in agreement with all of you that I think we've disenfranchised the voter. This being questioned at this point. And we don't know that what we did is what is right about their vote. So the consequences are, we're left hanging, and QR codes, how many people have a phone that will take that? Some of them don't even have phones, unfortunately. But I think we owe the voter a better chance of understanding of what their intent was.
If I had gotten the letter from Paula, signed by Paula, and I had a concern, I would have called Paula.
But it wasn't, it's not all his
It's-
responsibility.
I know.
It's their burden.
And also, too,
They have
you're
to
more
prove it.
informed than the average person. So you would know what to do, whereas most people would. I can see both sides of this
I
argument.
can too, but
I still say dismissal.
Okay, so Madam Chair, this is in the quasi-judicial boards that I work with on a regular basis, a procedure that I think works fairly well is for the chair in the first instance to make a ruling on a procedural question like is in front of you now, and that is whether or not there was sufficient service to satisfy the administrative code provision we've been talking about, right? If either side objects to that ruling, then it usually is submitted to a vote of the board, right? So are you prepared to make a ruling on whether or not you believe that the protest should be dismissed because of insufficient service?
Yes,
Yes. And what is that ruling? Should they be dismissed?
it should be dismissed.
Okay. Does anyone?
Sure, I'd like to vote on the record.
Okay, all right. So there's been a challenge to the chair's ruling.
Can I ask a question? If we dismiss it, where do we go from there?
Well, what I'm going to recommend to you is even if you dismiss it, that you move forward in the alternative, right? Had you not dismissed, right, these are the findings based on the record that you could make. Had you not dismissed it on procedural grounds, these are the findings based on the evidence that you would have been made as to the particular voters. Because what I'm forecasting is an appeal of the chair's decision, if it's ratified by the full board, on the notice question to the state board, right? The state board is going to make whatever decision on appeal that it deems necessary, right? But if it finds that the notice was sufficient, Then they would remand this case back to this board with instructions, my guess is to move forward on the evidence, to make find the notice sufficient and make the evidentiary findings. So we can either wait and see what happens, right? Assuming again that the chair's decision is upheld, and then come back and do the evidence, then make findings about the evidentiary portion. Or you can do it in the alternative. Had you not dismissed on procedural grounds, these are the voters the irregularities that had sufficient evidence to you, because you've heard the record is complete on those questions, right? Again, maybe you don't like that approach. You don't have to follow it, but the idea is to have in the order to say, we dismissed all of those. The protests were dismissed by the board, but if that ruling is overturned, based on the record, these are the voters that we found were, the evidence supported the fact that there was an irregularity at their votes.
Could you explain the opposite to us?
Right. So
If we say, we don't like this, but we think they followed the rules.
right. And in the alternative,
And then what happens?
if the chair's decision doesn't get the majority of the board's vote and the cases are not dismissed, then you just move forward with the evidentiary hearing. I mean, the evidentiary findings of fact and conclusions of law. You would just move forward with the same exercise, and that would then be the rule. Instead of the dismissal being the rule that the state board would look at first, they would just have the substantive findings of fact on the individual voters at issue, and then what conclusions this board makes about those individual voters.
And we can rule that we don't think that any of those have had any kind of effect on our votes. In other words, we can make that decision, right? On the three cases, all three of them or two of them or whatever, did have effect, maybe some effect, and we'd have to look at how we rank with, or how our votes count with the rest of the state.
Yeah, we wouldn't, in no event, no matter what this board decides about the notice or any, you are not this board would not be removing any voter from, any vote from the count. You wouldn't be doing that in the first instance. What you would do, all you would be doing is forwarding to the state board your findings that there were irregularities as to a subset of voters in Rockingham County. The state board then would have the job to look statewide over all the irregularities, if any, found in the 100 counties and decide, then the critical question, okay, were there enough to make a difference, right? To start removing those voters, right? So that's the state board's job. So this board in no instance would be taking votes out of its count without further direction from the state board.
All right, at least one case adding some back. No, I'm sorry. You're not taking them out at all.
Yeah, because again, we have the folks that died after they cast their votes early. Then we have some felons, at least, anyway, you know the categories by now. Okay, so I think where you are procedurally is the chair's ruling to dismiss all the protests, and then that's going to be submitted to the full board for a vote, and then you can decide. We'll take care of that issue, and then we can move to whether or not you want to go forward with the second piece of the hearing. So the question on the table is your ruling, Madam Chair, about dismissing all of the protests because service did not comply with 08 NCAC 02011 as to the affected voters. So that's the question for the board. For or against upholding the chair's decision.
So at this time, I'm asking all in favor of dismissal indicate by saying aye.
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 all for non-dismissal and moving forward in the other direction indicate by saying nay.
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 Okay. So the chair's ruling has been upheld to dismiss the petitions for lack of notice. So the question then is, do you want to move forward in sort of an alternative and say, had we not dismissed for failure of service, based on the information provided on these protests, these irregularities were proven to us by the standard required for protest hearings? Or do you just want to stop there? You could just stop there.
I think we need to move forward and look at the evidence that we have and decide from this point where we go.
Okay.
So we go back to our evidence and the information that was given as presented. And I'll let you tell us how to move forward with it and which one we'll start with.
Okay, all right. So again, the protester's burden, just to remind you, is to establish that there's substantial evidence to believe that a violation of election law or other irregularity occurred, right? So now what you're doing is going through the challenged votes and saying, you know, were they irregular when cast, right? Or illegal when cast, right? So that's the exercise. So I think perhaps the easiest way to do it is to stick with our protest 1, protest 2, protest 3 lists, right? And talk about the 5 voters. And again, I'm just going to read their names here for the record. In protest 1, there were 5 voters who the evidence was that they died after casting ballots and their votes were counted. So that's James Charles Lee, Barbara Ann Moore Walker, Harold Dean Atkins, Russell Dewey Jr. Wall, Willie Mae Lawson. So what would be proper when you're so inclined is a motion saying that as to those voters that there was substantial evidence presented that their votes were counted and shouldn't have.
They were counted.
Were counted and shouldn't have been.
Yes.
Because there was an irregularity.
That's what I have.
So they cast.
Is that appropriate for a motion, Madam Chair?
Yes, but we might want to go back and make sure we have the number that you mentioned, that Paula mentioned, that she brought before us was 2 deceased at the time that we did our canvas, right? Or was it?
Those are not on this list.
Oh, okay.
Well, of this 5, how many did we have that votes were in the system that we have determined now is not appropriate?
All 5 of these ballots were cast and counted for this election.
All of them?
All of them, all
How many
5.
were not eligible?
They passed away prior to election day.
Okay, so that's what I had, is 5 of the 7 were not eligible and should be removed.
Only 5.
It's only 5.
They're just 5.
It's just 5.
Yeah.
Yeah.
You were like I was. You were thinking about the 2 that we
Right. You-
canvassed.
So again,
I was on the fellow list, I'm sorry.
yeah, of these 5, the motion could be that they had a ballot in the official count, each of these 5 people. The evidence is that they either have an obituary or a death certificate showing they died before Election Day. I mean, that's, and therefore, you know, well, and the conclusion will be made by the state board about what to do with that vote, but that would be the motion.
So I'm not quite sure on where I'm headed with this.
Can I be helpful?
Yes.
Okay, all right. So we're going through each of the protests, right? And the board has to decide whether or not there was sufficient evidence presented that there were ineligible votes cast, right?
Right,
Right, counted, and cast and counted, right?
right.
Okay, so the first category of voters that were challenged were people that died. So these are all people that died before Election Day, but after casting ballots, and the testimony is that their ballots were actually counted, but they died before Election Day, right?
Right.
Right. So if the board finds that there's substantial evidence in the record that that's an irregularity, right, then you can have a motion and a vote as to those 5 people, that their votes were irregular and otherwise illegal.
Madam Chair, are we ready for a motion? I'll try again.
Well, I remember Paula saying that she had death certificates, she had all the evidence that she needed.
All
And
5.
so, yeah, for all
That's
5.
significant. So therefore, I vote that
You're not voting, you,
I move that we accept this as an exception and not that we pass on to the state that we felt like we did have an exception that needed to be rectified.
okay, do we have a second?
Okay.
So the motion is that those 5 were included in the count, but they were ineligible to vote because they died.
Ineligible to vote. It should be removed.
So the motion is, and the removal again is the state board, so your motion is that they were, those voters were included in the count, but they were ineligible because they died. Is that your motion?
Right.
Okay.
Okay. I'll second the motion.
Are we limited to the conclusions found in the statute, 163, 182, 10, 599?
Let me just see.
I just don't,
163, 182, 9 says conclusions of law
In regards to this?
in regard to this, yes. And it lists A, B, C, D, E, several things. One of which shows what Tom just said. There's substantial evidence to believe that a violation of election or other irregularity or misconduct did occur and might have affected the outcome of the election, but the board is unable to finally determine the effect because the election was a multi-county election. This is
We can't determine what a multi-county election would be. We only talk about what was affected in ours.
that's exactly what it says.
That's what I'm saying, is that we're going to basically count on what the state does based on other locality.
Yeah, that's right, because it's a statewide race. But I think, yes, I think I understood them to be one and the same. Did you hear a substantial difference?
I think we're saying the same thing.
Yeah,
Yeah,
I think so too.
so you're asking that they be removed?
Well, not that we're going to remove them, but the evidence shows that there was an irregularity and that person who deceased on election day voted and had their vote counted. That was an election irregularity. That's what the motion is.
Right.
Okay.
But the statute directs a conclusion that we cannot reach.
Yeah, we don't know if that's going to affect, right?
Right.
You know, again, this isn't the alternative because the protests were dismissed, but you know, you don't know because it's one county out of 100, you know. So we can't make the determination that it would decide the outcome, right?
Madam Chair, we have a motion and a second on the floor. I call the question.
All right. All in favor, say aye.
Aye.
All opposed, say nay.
Okay, very good. So that brings you to the second protest. And those were felons with votes counted. And you heard direct testimony as to one felon who cast a vote on election day. You heard testimony about others on lists from the state. If it's helpful to summarize some of that, I'm happy to summarize what I heard in testimony, if that's helpful. Otherwise, this is the second category to decide on.
So would you say that all three, that the verification pending was inconclusive, accepted, and then you remove those?
Well,
Not removable.
not necessarily. I think that.
The last one we did.
Right, so the testimony I heard as to the last two on the list is they had been discharged, right, from their obligations. They completed their sentence probation, were discharged. I didn't hear any
Just a minute, please.
I'm sorry, I'm gonna go.
Oh, okay.
I'll
right.
I'll be excused from this discussion.
All right.
I'll be back.
We might be still on it when you get
You
back.
go ahead and do it.
All right, why don't we just take a 5-minute break?
Sure.
Why don't we do that?
Okay.
So, we're ready now to go back
Is everybody
to
back?
the felons list.
Still working on felons?
Yes, still
Okay.
working on felons.
Madam Chair, could you ask Paula to recap for us just the totals under felon, so we're all working with the same numbers?
Yes.
Okay, from the information that was given earlier, the last two, Simon Genopoulos and Megan Burchell, according to our records, have completed their sentence and have been discharged. One as of August and one as of May.
So you had two
So-
on that list that weren't found,
Now, these two
were
They have-
discharged.
discharged. All right, that would be the last two on the
Okay.
list.
So are we saying 5 now?
1, 2, 3, 5.
There are 5 others.
5, okay. 3 of those we did not find on the felon list that has been sent to our office. Those 3 were Robert Benek, Douglas Palmer, which you heard from today, and Johnny Ray Hopper. But they were just not on our list.
But they're showing as being duly
Right.
registered.
Correct. And
By
then,
our list.
yeah, the first one, Walter Colby Carter, and the third one, Kevin Maurice Dickerson, were on the felon list for October. One for October the 30th, which would have been Walter Carter, and then the Kevin Dickerson on the October 15th.
And they did vote, and their vote is in count right now.
Yes, all 7
Okay.
voted, and their ballots did count.
So two of the 7, or 30% of them, of the group that we had, were not eligible to vote.
And you heard testimony from a third.
Yeah,
Right, that's right.
So,
that's 3 total on that.
so there's 4 that are verified.
So
3 or 4.
So it would be 2 on the list that
3.
normally would say they're, on the felon list and thus ineligible. And then the third who wasn't on the list, but you heard testimony that he in fact was a felon still on probation and he voted.
So that's 3 of the 7.
3 of the 7. 45%.
So what is your motion?
So you can find that those three were felons ineligible to vote, and they did vote. Their votes were counted. If that's what you're where you're headed for those three.
So we have 3 ineligible.
Madam Chair, I move that we ask that they be considered as ineligible. Well, the state will have to decide that. Yet, in our records find that there was a substantial number that were not eligible to vote, that did vote.
Okay.
Put it another way, that there were felons on election day, and they in fact voted.
Yeah, I think that's the proper way to do it.
Yeah.
They were felons and were allowed to vote.
3 ineligible, right?
Yeah, and those people, just for the record, were Walker, Kobe Carter, Kevin Maurice Dickerson, and Douglas W. Palmer Jr.
Okay. So we have a motion, we need a
Are you
second.
seconding the motion?
No, we'll just clarify.
I was just clarifying, what's the motion?
His motion was that we had 3 ineligible voters.
Vote out of the 7.
Oh, okay.
So we need
Yeah.
a
I'll second.
second. Okay, so it has been moved and properly second that we had 3 ineligible voters in the felons list. Is there any discussion? All in favor, say aye.
Aye.
All opposed, say nay. Okay. All right, next on the list. United Voters?
Okay, yeah, so this brings you to the third protest, or third set of voters that were challenged in this protest. Well, the third protest. And yeah, you can go through them however makes sense, Madam Chair, if you'd like me to summarize, or the director to
Yes,
summarize.
if you would summarize, but we've already, I think somebody asked a question, asked Paula, or a statement or something was made that, in her opinion, 3 should be counted.
Right, so the challenge was to voters that perhaps shouldn't have voted because their registration should have been canceled, right? So I think the testimony was all of the people on the 2 lists we're talking about, their votes were in fact counted, right? And I think that's clearly in evidence. And the question is whether their registration should have been canceled such that they weren't eligible to cast a vote, right, on election day.
All 3 of them.
Yeah, as to the first category of folks, I think the testimony from the director reflects that she received the initial card mailing back, but the time periods but she hasn't received the follow-up letter back as undeliverable, right? And she has no information other than that, about where they live or the fact that they don't live. So what you know is that they registered other than the one that the director testified works part of the year in the United Kingdom. She did mention that Ann Bailey Smith works part of the year in the United Kingdom. But what the director's evidence, or the testimony solicited through the director, was that they're registered and that they voted, and she didn't know anything more about their eligibility other than that she had sent the postcard returned, she followed up with a letter and hadn't been returned, right?
So we're looking at 3 eligible voters.
So if there's no action to be taken on them, you can move on. Or you can, if you find that they're, well, I don't want to confuse it. Do you have any other questions about those three?
Anybody have any other questions?
Did we have verification that they received one mailing?
The first mailing was sent out, it came back undeliverable. The second mailing went out, and we have not received the second mailing back
For any of the three?
for any of these three.
Refresh my memory, why did we send out the letters?
It's just in case, for some reason, that the post office or some error occurred, but it's also required by the state board. Normally, we send 2 verification cards, it's the first and a second. But in presidential elections, like this one, you send a card, and then you follow up with a letter.
Are you saying, but I'm still confused on why you sent the letters or the cards.
If we were required by the state board to send,
So you received 2 with verification, right?
these,
Or not?
all 3 of these verifications returned undeliverable with their cards. But we did not get their letters back as undeliverable.
So these 3 folks they were registered
Yes,
prior to the election.
and they could have made a change of some kind. See, if
So what prompted you to send out that?
there was a change of some kind that prompted this.
Okay.
Normally, this would not have occurred because they were already registered. But for some reason, something was changed. Whether they changed their address, they got married, something initiated this card being sent to them, where otherwise it would not have been sent out.
But there was one person in there who had actually voted and was eligible.
All 3 of them were eligible to vote according to our records, and all 3 of them's vote was counted.
So again, just to remind you, maybe it helped to think through the burden, right? So the protester had the burden to prove to you that there was an irregularity or misconduct, right? A substantial evidence of an irregularity or misconduct in the election.
Can I share a postal situation here at court occurred at my place? I received 7 cards with a water bill on it in my mailbox. So you don't know who sent what where with the current postal system. I hate to say it that way. I think we gotta let it, I mean,
Yeah, so-
these people technically could vote.
Yeah, that's the question. Is there substantial evidence that there's some irregularity as to these voters?
I have one more question. So how were you informed of the change that prompted you to send out the card and the letter?
That's why the card was sent.
But what prompted you?
The precinct officials made a change
Gotcha.
when they
Okay.
voted.
Okay.
Yeah. That's why I don't know what the change was.
Gotcha.
Yeah.
Okay.
We might get it.
So now, what were you getting ready to say? You getting ready to do a
I'm
motion,
ready.
right?
I would move to approve 3 here, no deductions.
I say,
Okay, it has been moved and properly second that we have 3 eligible voters for denied voters. Is there any discussion?
So we're voting to accept these.
So, no, you don't have to accept it. So what you're essentially doing is
leaving
finding
it
there's not
there.
substantial evidence of an irregularity as to these voters,
Yeah.
right? And I'll say the same thing as to the other felons with votes that went unaddressed, that they were unaddressed, right, because you didn't find substantial evidence of an irregularity such that they should be removed, right? Is that accurate? Maybe just for the record, we can add them as well. So the idea here is as to these three, which is Nicole Lauren Dowles, Ann Bailey Smith, Dawson Cole Stamey, and also the other felons on the list other than the three that were found that were irregular.
That's not the felon list.
No, I'm just going back in time a little bit. I'm combining it just for the record.
Well, you're confusing me.
I know. So as to the felons that weren't removed and these three, there's not substantial evidence of an irregularity such that you would find that there was a problem with their votes.
Right.
Brian's trying to get us to make the appropriate findings before we get to the point of making those. Okay, so the finding is that those three were eligible to vote. There was no substantial violation.
No substantial evidence showing there was an irregularity, right? The record doesn't show substantial evidence that they should have, that their vote was irregular or unlawful, right? And the same with the other felons. So that's the point. And if you make that, that's the motion and the vote, then you can move on to the next category.
Okay, that's the motion. Now we need to vote.
Right.
I'm not sure, Madam Chair, what we're voting.
Again?
So what you're voting on is that there was not,
That these are eligible and there's no,
there's no substantial evidence, right, as to
if you're
these
not
voters.
listening, you're not gonna know.
There's no substantial evidence in the record that these voters were ineligible or they voted illegally, right?
We're not on the felon list. We're on the eligible, but their name was taken off.
I understand. I'll back up and do that again. I'm sorry to confuse you. I was just trying to combine motions, but I understand that caused more
We've already
confusion.
done the motion on the felon.
Right, I'm going to go back to that. So
Okay.
let's just do these three.
Okay,
I made the motion.
I said,
he second, and now we're getting ready to vote. All in favor, say aye.
Aye.
All
Madam Chair, I'm
opposed.
still not sure of what we're voting on.
Okay, you're voting on the fact that there's not substantial evidence in the record to find that Nicole Lauren Dowles, Ann Bailey Smith, and Dawson Cole Stamey, their votes were irregular or otherwise illegal. There's not substantial evidence in the record of that. So that
This is on the list that were removed and were wanted to vote and voted.
Denied.
Denied. We're on the denied list.
they voted, and their votes were counted.
Right.
Right, and there wasn't evidence showing that that was improper or
Right.
otherwise irregular?
I'm sorry.
No, I'm sorry, I confused you by trying to combine something that I shouldn't have, I apologize.
And plus, it was lawyer talk.
And I'm bad for that too, and y'all
I mean,
just
I'm
call me
just
out when I
telling
do
you,
it, please.
I started out saying 3 eligible voters,
Yeah,
and then we wanted to add some to it
I know, I'm
to
sorry.
make it, you know.
My vote is aye.
Did we all vote?
We all voted.
All right, now I'm really going to confuse you, but I'm going to take you back in time, because what I'm thinking about in my head is this order I've got to write after we get out of here, right? So what I want to make sure is I've got you all to decide the things that I need to put in the order. So now I'm taking you back to the felony list. You found that there was substantial evidence of irregularity as to 3, right? Those 3, but there were others on the list, right? And so what I'd like for the board to say is there wasn't substantial, and I think this is implied in your decision, there's not substantial evidence in the record that the other folks listed on the protest concerning felonies should have been removed or were irregular or unlawful, right? There wasn't substantial evidence of that, right? Which is why you didn't take any action on them, right, before. So that would be the motion, that as to the remaining folks other than Mr. Carter, Mr. Dickinson, and Mr. Palmer, as to the others on that list, there wasn't substantial evidence that their vote was
We
irregular or
don't consider
unlawful.
45% substantial.
As to as to those as individuals, as to those as them as individuals, right? Right.
So moved.
Okay, thank you.
So did we get a second?
Second.
All right. Any discussion? All in favor say aye.
Aye.
Aye. All opposed, say nay. All right.
All right, I apologize for the confusion. Thank you for indulging me.
So do you have it?
Okay, so now you have your final list here. And again, the testimony was that everyone on this list of North Carolina removed voters with votes did in fact vote, right? And the question is, was there some irregularity or illegality with their vote such that it's called into question? And you heard from the director whose office did quite a bit of work to try to verify, right? The testimony was that 2 of these folks had in fact died, right? So yeah, Mr. Gary Clifton Matthews and James Williams Matthews both died, one former on 10/24, the latter on 10/11, and they did in fact vote. So that's a similar analysis to what you went through, on the first protest, right? And then you had the various information about the other folks, and you can take them in turn. Clifford Bruce Shores moved out of Rockingham, but didn't move until 10/18, which was in the 30-day window. And I believe the director testified that they would have been directed back to vote here anyway because they didn't move into a new location 30 days before voting. Daniel Lewis Leroy heard the issues there about a merger of votes, but it's not a duplicate voter and was fixed. And then Ms. Graves, who did in fact move to Maryland for assisted living in September.
Right.
Annie Hall Frederick, the first instance was just an administrative mistake, and that was fixed. That she didn't vote twice. She voted once. It was counted once. It was just a wrong name attachment in the system that was subsequently fixed and counted properly. Then we have the 2 deceased, and then we have Glenn Anderson, Barbara Crowder, and then Annie Hall, the proper vote for Annie Hall, who had some question about where they lived, and there was testimony about the contacts with them. Anderson still lives in Rockingham, Crowder still lives in Rockingham, and Frederick didn't respond to the call, to the voicemail. But no information otherwise that I recall from the record, the evidence presented to you about their where they reside. So, question would be, so substantial evidence in the record that any of these, the folks we just went down and read out their names, their votes were irregular, or otherwise, they were ineligible to vote, and they did in fact vote, and their votes were counted. They shouldn't have been.
So, I need a motion. Is there a motion?
Oh, we'd already gone through this process.
Not as to this subset of folks. Yeah, this is the last. This is the last.
This is the last
The,
night.
the last, yeah.
Last
This
night.
is it.
Yeah.
This is the first time you've
How many
considered.
we're removing this time for?
How many are you going to remove and who is the question? Yeah, and it seems like you've got 2 that are relatively straightforward because they died.
Deceased, right.
Right? And then another one that may be fairly, well, it depends on how you look at it, but one, the evidence is that she moved to Maryland in
Right.
September, right, which was more than 30 days prior to Election Day. And is there another?
We we have 2 Fanny Halls.
But
Only one vote counted.
But only one vote counted.
Right.
The testimony was, there were originally 2, but administratively that was resolved, and there's only one vote for Ms. Hall in the count.
State the motion and I'll make it.
Okay. Well, one motion could be that as to Gary Matthews and as to James Matthews, who both voted but died before Election Day, and as to Helen Graves, who voted but moved from the county in September, that their votes were irregular.
So moved.
Second.
All right. It has been moved and properly second, as was stated. I'm not going to go back and try to remember everything you
That's okay.
said there. Is there any discussion? All in favor say aye.
Aye.
All opposed say nay.
Okay, and then the final action is just as to the other folks on that last list, there wasn't substantial evidence presented in the record of any irregularity or illegality regarding their votes.
I'll move on that also.
I'll second it also.
All right, has been moved and properly second, as was stated. Is there any discussion? All in favor, say aye. Aye. All opposed, say nay. This is where we are.
All right, Madam Chair, thank you very much. So the requirements now is that this board, within 2 days, prepare an order for transmission to the parties and also to the State Board of Elections, outlining your findings of fact and conclusions of law, which in this case are, in the first instance, dismissing all the protests for lack of proper service, and then in the alternative, going through and addressing each voter that was the subject of the protest. Okay? And so I'll work on that and work with the director and the chair on the final order for your signature in the next 2 days. I don't know if the director has any additional business for you today or not.
She has for me, but it doesn't have anything to do with this. All right. So we're finished, do I have to say?
Yeah.
That's it. Hearing is over.